Thank you, my lord.
You're still under oath, Colonel?
Yes,
Yes.
that is correctly confirmed.
Thank you, my lord. Can I, my lord, with the leave of the court, may I hand in this copies to the witness so that I can ask the witness to read it for us?
Okay.
Well, we just want to put on record that the interpreter is now Mr. Lebelo.
Okay, thank you.
Okay. Morning, Mr. Mohan.
Good morning.
You see the documents I have given to you.
Yes, I see them.
Yes, what is written outside?
Statement regarding interview with the suspect.
What is statement regarding interview with suspect?
Okay. Let's go to paragraph 1.
Paragraph ya mathomo.
But if we paragraph look at
You can place it on the record. What is the SAP number for that form?
SAP number ya yona mo formong e nngwe e reng.
what in SAP number at the phone?
SAP 3M in bracket small m.
SAP 3M in brackets small m.
Yes. My lord, it's SAP 3M in brackets small letter m. Yes, continue read. After the emblem, South African Police Service, read it.
South African Police Service instruction statement regarding interview with suspect.
But in a cook food of Konobuti, Kwakubegan is Katibukulian so.
Yes. Can you read paragraph 1? Completion on statement.
Paragraph ya mathomo.
Completion of statement. The station commander must consult with the prosecutor on circumstances in which the prosecutor requires that the witness statement of a suspect be obtained.
Oh, prosecutor finally Akulum. Prosecutor finally Akulum.
It's the other way around.
A.
The station commander must consult.
Station commander kufanele akhulume no prosecutor ezindaweni lapho ke prosecutor edinga ukuthi kube kukhishwe warning statement kamsola.
Can you just read the whole paragraph so that yes, thank you.
Paragraph ye nngwe gore e tlo kgona go tolokega botse.
In every such case, the suspect must be interviewed and this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect is arrested or not.
Wo zonke isikhathi umsolo uma kufanele ukhulume naye kufanele lesi statement sigcwaliswe. Le statement ke kufanele ukuthi sifanele sigcwaliswe ngazo zonke izikhathi lapho ke umsolo ukukhulunywa naye. Kungabhekiwe ukuthi umsolo useboshiwe noma akakaboshwa.
Paragraph B.
Paragraph ya boraro.
3.
Paragraph B.
B.
Yes.
The member who conducts the interview with the suspect has to complete the statement fully in the presence of the suspect.
Kuthiwa ke ozobe khuluma ke nomsolwa ufanele agcwalise ngokuphelele istatement lesi phambi kukamsolwa.
Okay. Paragraph C.
Paragraph C.
If there is not enough space on any of the pages, the member must continue on a separate follow page. This follow must be signed by a member, suspect, interpreter, and the commission of oath, and must be attached to the statement.
So lana ke uma ingekho indawo eyanele ekhasini iphasa lifanele liqhubeke libhale kwelinye ikhasi leli khasi ke lifanele lisayindwe futhi ilona liphoyisa umsolwa uToliki futhi ke kube ne-commissioner of oaths and futhi lifanele linamathiselwe ku-statement.
Paragraph D.
Paragraph D.
The Commissioner of Oath must sign on every page of the statement.
Kuthiwa ke uCommissioner of oaths kufanele asayine wonke amakhasi statement.
Yes, paragraph.
The Commissioner of Oath must sign on every page of the statement. If the suspect is a child below the age of 18, the parent, guardian, and appropriate adult must sign every page of the statement.
So uma kuwukuthi ke umsolwa useyingane engaphansi kweminyaka e-18 umzali noma omgcinayo noma ke umuntu omdala okhona ufanele asayine wonke amakhasi estatement.
As a court, please, my lord, sorry to interrupt my learned friend. The state objects against this line of cross-examination by my learned friend. Firstly, we don't see what the relevance of this cross-examination is. Secondly, the witness said yesterday that the interview on the 17th was not a warning statement. And if one looks at what the exercise that my learned friend is busy with, this regards a warning statement, unless if my learned friend intends on canvassing a warning statement of accused accused number 2 with the witness. But if one looks at paragraph 1, it states clearly there that this form is applicable in the case of a warning statement, and that in that case, the station commander must consult with the prosecutor. So whatever follows, my lord, is subject to the obtaining of a warning statement and not an interview that the witness has testified about.
Yes, ma'am.
Thank you, my lord. My lord, I think I've clarified this yesterday, my lord.
No, clarify it again because Mr. Baloy is now objecting.
Yes.
You remember my comments yesterday?
Yes, my lord.
Yes.
My lord, I am not referring the witness to this paragraph because I'm saying that this document was signed or completed by any of the accused.
Fine. What is that document?
It is a warning statement, my lord. And
Okay, fine. Accordingly,
it's the instructions that are given, yes.
when one wants to take a warning statement,
For the police officer to record when he's interviewing the suspect, my lord.
is it for an interview or for the taking of a warning statement?
It is for an interview, my lord. That's why I read paragraph 2, because
Okay,
it says
fine.
the member, paragraph B, my lord. It says
Let's start from the beginning. What is that document for? Because Mr. Baloy says it precedes the taking of a warning statement, and you are saying it's for an interview.
my lord, if I can just repeat myself, my lord, yesterday the witness testified that they were interviewing the suspect in the
fine.
courtroom.
Yes, yes.
Then my question was, my lord, was it recorded? Then I said, where was it recorded? Then I went back to this form to say, this form says the member who conducts the interview with the suspect has to complete this statement fully in the presence of the suspect. And
Okay.
paragraph A, my lord, says, irrespective of whether the suspect has been arrested or not. In other words, my lord, whenever there is an interview between the police and the suspect, that interview has to be recorded because there are allegations, there are constitutional rights that are explained by the police officers at that time.
Fine. And this form, what is it for? The very form. Is it for an interview?
It's for the statement regarding interview with suspect. It's written clearly on the instructions, my lord. In statement regarding interview with the suspect.
Yes, Mr. Baloyi.
And as a court, please, my lord, this is where, with the greatest of respect, we submit that my learned friend misses the point.
Why don't you bring, okay, you know what?
Yes.
Just bring me the law.
Yes.
Okay, because you're
Yeah.
at different
Yes.
codes.
Yes,
Can
but-
you give me the authority you're relying on?
Yes.
And please, Ms. Mshololo, give me the authority you're relying on.
Yes, but-
Can you adjourn for that?
Yes, but can we just make this one point before we adjourn, my lord? Just this one point. If one looks at paragraph A, it says clearly the station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement.
So the prosecutor must also be involved.
Yes, and this is the emphasis must fall on warning statement. The station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement of a
taken.
suspect be obtained. And secondly, it says in every such case, in other words, in every such case where a warning statement is required. It doesn't refer to any interview with the suspect. And my learned friend is now opines that in every instance, when a police officer conducts an interview with the suspects, then this process must be followed. It's only in the case of a warning statement.
And that, as I understand the law, that
Yes.
precedes the charging
Yes.
of the suspect.
In-
Okay, can you get me the law so that we don't argue in a vacuum?
As the court
How long do you
is-
want me to adjourn?
My lord, maybe 30 minutes because I've already have the authorities. I'll just make the copies.
Do you have any authorities for yourself?
We still have to look up, but it shouldn't take that long.
Okay, 45 minutes. come to Ms. Mshololo.
Yes.
Your objection. What are we busy with the sergeant here?
Yes. Indeed, my lord, that is the nub of the matter.
Yeah, what are we busy
We're
with?
busy with a questioning or interview that Sergeant Mokhane conducted with a suspect.
Yes,
And
the boardroom.
yes, in the boardroom. In other words, we're not busy with the taking of a warning statement,
Yeah.
but just merely an interview, an informal interview that a police officer had with his suspect.
Is that the background to the
Yes.
issue?
Indeed, ma'am.
Yes, Ms. Mshololo, let me understand you. What are we dealing with?
My lord, we are dealing with the interview which took place between the suspect and the witness at the boardroom.
Right.
Where,
It's an interview.
it's an interview.
Yeah. What about it?
Yes. Then, my lord, my submission is that because the witness said he explained the rights, he explained the allegations, and the accused responded. Therefore, that interview ought to have been recorded.
Right.
Yes, my lord. That's
If
where
it's
we
not
are.
recorded,
It's my submission, my lord. The court can make a ruling.
yeah, fine. Is that what you are dealing with, and is that what your colleague is dealing with?
That's what.
Now, how does this form come into play?
My lord,
This form, which you say the court must peruse.
it's because, my lord, this form says statement regarding interview with the suspect. Hence, I referred this witness to that form. And it says, my lord, on the first page, statement regarding interview with suspect, paragraph 1, my lord.
Oh, you're reading paragraph 1 where it says the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not.
Yes.
Where any space provided on the form is insufficient, continue
Yes.
on a folio attached to the folio of that page.
Yes.
And folios must be signed by the suspect, the interpreter.
Yes.
So you are saying this form is applicable, in other words?
My lord, that's my respectful submission. my
Okay,
lord, to
you want me
say-
to rule on that?
So to say, during that interview,
It must be signed, the form must be signed according to you.
it must be recorded, my lord.
Yeah.
Although, my lord, I am not saying that the witness was bound to use this as its.
No, let's have, the
As-
submission is that it must be filled, this form, or what is your submission?
Yes, it must be.
It
My lord,
must be filled.
My lord, can I just refer this honorable court to just one judgment?
Which one is
I'll be
that?
quick. I'll be quick, my lord. I won't waste the court's time.
Which judgment is that?
It's the Henry Foster and the Minister of Safety and Security. It's judgment by,
Others.
yes.
I've read this judgment.
Yes, yes.
It's about damages,
Yes, my lord.
unlawful arrest, and the assault of a suspect who subsequently, obviously, the charges were withdrawn because there was not sufficient evidence.
Yes, my lord. But there's a principle that I want to bring it to the attention of this
Okay,
court.
fine, bring it. Which principle is that?
Thank you, my lord. On page 23, paragraph 28.
Wait, I'm going there.
Yes,
Page. Wait.
page 23.
Wait. Page 23.
Yes. Page 23. It's paragraph 28, my lord.
Paragraph 28.
Yes.
Yes, put it on record.
Yes, my lord. Paragraph 28, under warning statements, my lord, it says, express provision is made in every warning statement in this court's jurisdiction for the completion of a warning statement each and every time that a suspect is interviewed. Paragraph 29, the constitutional protection provided for in terms of Section 35 of the Constitution to arrestees is embodied in this principle. There is no justification for any interview with a suspect who has been arrested or called in for questioning to take place without a warning statement being completed. Paragraph 30, my lord. The very term warning statement indicates that the person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my lord, I have not finished. I'll skip this. And then paragraph 34, my lord, the next page, on page 24, which says, it was startling to hear that both defendants' witnesses, who were experienced policemen, believed that they were entitled to question a suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last reference, my lord, is just one paragraph before it goes to, I'll summarize it, my lord, paragraph 38.2. Paragraph 38.2, I'll be quick, my lord, wherein it refers to the warning statement which is headed, statement regarding interview with suspect. Paragraph 38.2, my lord. 38.2.
Yeah.
Yes, my lord. It says, the warning statement which is headed, statement regarding interview with suspect. It is referred to as SABC 3M document and embodies 12 pages on the cover and on every first page under the insignia of the South African Police statement. The statement regarding interview with the suspect. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my lord. There is no basis in law on paragraph 19, my lord. Paragraph 39. Yes, paragraph 39. There is no basis in law or fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not, this is for the judgment of this case, my lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. Paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that the suspect may now be taken to court is to be frowned upon and not condoned by this court. It's
a single judge. It's a single judge who says that.
Yeah.
Oh, it is.
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I've read it into the record, it must be completed whenever there is an interview between
Who must complete it?
It must be completed by the person interviewing the suspect.
By the police person?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded. My lord.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the Court of Co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the Court of Co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trier of fact, and this court can only interfere with a finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he expressly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under the... Somebody interfered with it. Where's the 4th page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah. And then paragraph 92 reads, it's page 4.
Yes, ma'am.
One of the main contentions still read page 19. Paragraph 88, sorry. He says, it is not necessary to set out the evidence adduced in the court below, as Manamela A.J. has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a right protected by the Bill of Rights leads to exclusion. See in this regard, as versus Ndlovu and others, 2002, SCA, ZACA 70, 2002, to SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC 8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that it does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice in ways that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia in S versus Mtombo said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution. If, on the other hand, the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Krichler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes, ma'am.
So this case of Hodis, it's not the be it and the be all.
That's the court cases.
I've quoted you two constitutional cases
That's the
where they say even unconstitutionally obtained evidence. Do you have that? Hello? Key, Attorney General of the Transvaal. Let's read it so that everybody knows it. Right? Do you have it?
Yeah, we just find it quickly, my lord.
Yeah, just find it. Yeah, you've got Mr. Computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court cases.
Yeah, it has no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Oh, my learned friend is finding it.
No, man, just find it. Because people, when they read the Constitution, they all say if the evidence is unconstitutionally acquired, therefore it is not admissible. You further go and examine the phenomena and the exigency under which that evidence has been acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order, and the perceptions of the public regarding the application of fairness. After that, we can conclude whatever cross-examination you want.
May other counsels be given opportunity to make submissions?
Yes,
for the
yes,
ruling?
no, everybody,
Thank you, ma'am.
everybody. So Hodes has got a point, but the point is, as I understand the evidence of this witness, predicated on that interview, amongst other interviews, he repaired to Carltonville to go and further investigate. That's what he says, not me. When they got to Carltonville, Ginida came and they went to see the personnel manager, and the personnel manager made a statement to them.
My Lord, can other councils respond at this
Yeah.
stage
No, we're
before
going to
the
read this.
ruling is made?
We're going to read this, and then everybody is entitled to
Thank you.
respond.
As the court pleases.
Sorry, Rose, let's go and fetch that case. 1996, Attorney General of the Transvaal. Just, I'll check it. Do you have it in your computer? Yeah, Key, this is Key. This is Attorney General of the Transvaal, 1996, Constitutional Court, Kerso. You got it? That one. Yeah, that's the one. Sorry. No, that is the one. Yeah, I forgot class. Baloi, my registrar found the law.
Yes, it's paragraph 23 of the judgment.
Yeah, paragraph 23.
It says at times fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Yeah. Go on.
Well, and it says if the evidence to which applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. It will then be for the trial judge to decide whether the circumstances are such that fairness requires the evidence to be excluded. It follows that the applicant is not entitled to an order from this court in these proceedings, that the evidence secured as a result of the searches and seizures will be inadmissible in criminal proceedings against him. I don't think the...
Yeah, read that tension. Why critical reasons like that?
Oh, okay.
Because some of us may not know it. He talks about the tension.
There's paragraph 13. Says in any democratic criminal justice system,
Yes,
there is a tension between, on the one hand,
that's it.
the public interest in bringing criminals to book,
Right?
and on the other hand, the equally great public interest in ensuring that justice is manifestly done to all, even though suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties
Stratagems.
and ingenious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Okay, yes, Mr. Mnisi. Mr. Gomez, sorry. Any submissions?
Court, please. My Lord, my submission, firstly, I would agree with the principle that each case is decided on its own merits. Under the circumstances of this exercise or this discussion is that when we look at the interview that was conducted or was held in the boardroom, it was held under a different pretext from the officer. He was booked out from the police cells to the boardroom under a very wrong case, case 163 of 10/2018. When an interview is carried in terms of a docket that is the accused is now facing on the charges of a case docket under 636. My Lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case number 163 and changing tune when they are in the boardroom. So now the accused is no longer, as per the evidence of there's no evidence before this honorable court that accused was interviewed in terms of the Onongoma case. But all that we know before this honorable court is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is that fair for the accused in the course of administering justice to be taken by surprise to say, this is what we arrested you for, but now we are subjected now to these particular allegations. Please provide us. To what extent did the rights were explained, especially under case number 636? Second fold of my submission is that it's based on the evidence that is before this honorable court that at all material times when the accused number 2 is booked in and out, there's no indication, there's no entry that he was subjected to an investigation under case number 636. So that would tantamount to unfairness, and that will jeopardize to proper functioning of justice system. In this regard, as the facts are as matters are decided on their own merits, it is my humble submission that accused number 2, they should have actually gave him a clinch or an information. He's the one that he received an information earlier that he is involved in the murder case of Senzo Meyiwa. But when he is booked out, when the rights are read in terms of Exhibit LL, they are read under a very wrong case number.
Okay, thanks.
That's my submission.
Yes, Mr. Nisi?
As it is the court, may.
Yes, no problem.
As it is the court, Madam. Madam, I think there's a bit of a confliction.
Conflation.
A conflation of issues.
Yeah, I mentioned them.
Yes, Madam. When this issue was raised by my colleague Advocate Mshololo, and indicated that there is authority, or in fact, each time the suspect is being interviewed, that interview needs to be recorded. Then my colleague for the state stood up and said, but that's not always the case. Then the court also got in and said, as far as the court understands the process, is that a warning statement is only supposed to be filled in as and when the suspect is being charged for him to be prepared for court. My colleague further insisted that, but that is actually not exactly the case. That is when this commotion or this argument actually started. In order to satisfy himself, then the court invited all parties to bring authority before court to support their submission in respect of what they believe in. The defense, my colleague, Advocate Mshololo, brought a judgment that specifically addresses the issue that the court said, bring judgment, bring an authority to convince me. We were expecting the state as well to bring a judgment that will go contrary to what the judgment that has been brought by my colleague is saying. The state hasn't.
Okay.
Instead, what is happening now, my lord, we are trying to confuse two issues that are very distinct. Whether or not it is in the interest of justice, that evidence that is sometimes unconstitutionally obtained should be obtained or what. But this is not the crux of the investigation as to why we actually had to come here. In the judgment of Hodes SC, it's very clear. The statements regarding with the interview with the suspect, it's very clear. Each time there's an interview with the suspect, whether or not that suspect is arrested, this document must be filled in with no exceptions. I won't go back and refer to what my colleague has said.
Yeah, I've heard you.
But now, there's also a referral to the case of, to what the Honorable Judge Prela said. These two cases are totally distinguishable because in the Prela case, my lord, it was not about whether or not each time that a suspect has been interviewed, this document 3M in brackets, small letter m, must be filled in. It was only a determination on whether or not the statements that were used in the decision of this case should be used against the accused person in this case or what. So these two cases are totally distinguishable. As I am standing here, my lord, I am still expecting the state to present to the court an authority that says, no, it is still fine for a suspect to be interviewed without having to fill this SAP 3M in bracket M. The state is not
Okay, I've heard
forwarding such information. So basically, we are not saying, my lord, that the court should make a decision here and now.
I'm not going to make, I'm not confused. I'm not going to make a decision now. You're arguing the law. I'm going to make a decision at the end of the case. Don't go about saying, hey, the judge lady.
That is what
I'm listening to the principle of the law. And the decision which I will make will be predicated in the sense that I gave all of you a chance for the input of the very issue which is being debated in this case. But I'm not making a finding, I'm not making a ruling, never.
Yes, my lord, that is basically would have been my next point.
That I'm going to make a ruling.
And no, I intend to say, my lord, that when my colleague, Advocate Mshololo, raised the issue of the interview with the suspect in the boardroom and whether or not this form was filled, it should be something that should be, my colleague should actually be allowed to proceed with that form of cross-examination. It will then only after all the evidence at the end of it all has been heard.
I said
then
that,
the court
ask your colleague, I said that to her. Didn't I say that to you, Ma'am Sholol? That I'm not stopping you from going ahead with the strategy of the cross-examination you are course on. Did I say that?
My lord, the problem is that when after
All I said, do you admit that this form doesn't have statutory application? That's
My
all.
lord.
And you said no.
My lord,
But I never said to you, stop your cross-examination. Never. I will never say that to any counsel.
My
Never.
lord, after I've been granted that leave, my lord, the state objected.
No,
the
but
state objected.
I decide whether you continue or not Mr. Baloyi. Okay.
The state objected, then the court said we must make submissions.
Yeah.
That's where we're in, my lord.
Yeah, fine.
Thank you.
Yes, Mr. Numalo. Oh, are you still on?
No, I just wanted to wrap up, my lord.
Oh, I said, okay.
Therefore, my lord, it will be very precarious. Actually, it will be a precarious procedure to, at this point, decide this thing as if it is final.
Who's going to decide it? I told you I'm going to decide at the end of the case.
The reason why I'm saying this, my lord, is because I hear already there are authorities that have been referred to which do not specifically deal pertinently with the issue that the court has raised.
Yeah, in other words, you and Mr. Mshololo and Mamalo and Mr. Mugumezulu, Baloi, at the end of the case, they're still going to have to argue
As it please the court, my lord.
about the admissibility of these statements and confessions and pointing out how much.
And more particularly with regard to that interview
Yes.
that was held in the
That's
boardroom,
it. You're still
where
going to
this form
argue.
was not filled. Thank you, my lord.
At this
That would be
stage,
my submission.
I had two contrasting legal submissions.
Yes.
That's all.
Thank you, my lord.
All right. Yes, Mr. Mamaru. Hey, my daughter. And I may just add, other judges just keep quiet. They keep quiet, and then yes sir, yes sir, yes sir, and thereafter they come with a decision. I don't do that.
As it please the court. Yes, that's
I don't do that.
Court should not only be a passive umpire.
Yes,
as it
yes.
please the court.
Yes, Mr. Mumal.
My lord, my starting point will be that it is not enough for the police to use the SAP 14A, because we've been hearing that the SAP 14A was used, that is before and after the accused, that is accused number 2, was at the boardroom.
That's a guideline.
Yeah, as a guideline. I'll re-emphasize and follow the decision of Holtz SC to the effect that whenever the interview is conducted with the suspect, it must be recorded. And the statement regarding interview with suspect form must be used. I'm having the understanding, my lord, that if that is not followed, then it violates the accused rights in terms of Section 35 of the Constitution, and therefore, in terms of Section 35(5) of the Constitution, it stipulates that evidence obtained in violation of the accused rights must be excluded if that, or the admission of that evidence will render the administration of justice into disrepute. This form gives an obligation. It's an obligation to the police to say whenever the interview is conducted with suspect, this form must be used.
Yeah, I agree with you. You see, it's incumbent upon you as advocates of this court to make representations to the Minister of Justice to pass regulations
Yes.
addressing the very exigence.
Yes.
Manje antet niyakhuluma nje.
It looks like there will be a number of representations.
Yes, you have a right
In this
as
case.
that's how the law develops.
Yes.
When there's a lacuna in the law, the persons who practice in this court, they must take it upon themselves to address that lacuna so that the Minister of Justice, Lamula,
Yes.
must address that.
Yes.
Because it's going to recur. That's why you have 9 provinces and you get 9 different decisions in all the 9 provinces. Okay.
Yes. Thank you, madam. Thank you.
Mr. Msholo, you are continuing.
No.
You are continuing with your cross-examination.
No, my lord, we're still waiting for this.
No, you are continuing with your cross-examination. Is that not so?
Yes.
Yeah, now we listen to Ubaloi. Remember I said I'm not deciding the issue now. I'm going to listen and hear all of you, what you say. So Baloi must say whatever he wants to say. Thereafter you continue with your cross-examination.
As the
Okay.
court business, my lord.
Is it so difficult, madam?
As the court business, my lord.
Yeah. Yes, Mr. Baloi.
As a court, please, my lord, we just want to come from a slightly different angle, and we raise an objection based on purely issue of evidence, of relevance. You know, my lord, we objected on the basis that the questioning is not relevant in the sense that my learned friend was pursuing a line of questioning that says the accused number 2 made a statement. From the evidence that has been given by the witness, I'm not even sure if one can put it as high as that to say that the accused made a statement. what we have before court, my lord, is
He made a denial.
yes, it's evidenced by Sergeant Mohani that says we convened in the boardroom with the accused. I warned him according to his rights, and as a suspect, I informed him what the purpose of the interview was, and the accused gave an explanation. I don't know if one can say that it's a statement. He gives an explanation. He says he doesn't even tell him about the date on which the offense was committed. He says, I'm investigating the case of the death of Mr. Senzo Meyiwa. And the accused then, out of his own volition, says, well, I know about that matter. I read about it in the newspaper. Is that a statement? We submit with the greatest of respect, my lord, that if one looks at the form that my learned friend wishes to use to cross-examine this witness, it refers to some sort of a formal statement. All that Sergeant Mohan was doing was to offer the accused number 2 the opportunity of an explanation, and he says, I was at work, and that defense is pursued. Suppose, my lord, for one moment, that if the explanation that the accused gave that he was at work, if the cloaking records confirmed his version, that would have been the end of the matter. There would have been no need to pursue the matter any further. It could have never been the intention, and even with the judgment that my learned friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to embark upon, that should be followed. These are just preliminary issues that are aimed at establishing whether a formal statement or a statement should be obtained from the accused at a later stage, and which happened in this case, my lord. After these preliminary processes, a formal statement was obtained, to which the investigating officer will refer to when he testifies. It can never be in the intention of the judgment by then Judge Holders to say that in every instance where there's that preliminary inquiry, that this formal process should be embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect this. It envisages a process where a formal statement is intended to be taken from an accused. And if one looks at a discussion under this topic, it all results under Section 217, which deals with the confession. So we submit, my lord, that the intention here with this form and with the process that my learned friends wants to embark upon is, if, or in the case where a statement of some sort has been made. We also want to refer to the judge's rules, my lord. We know that they have, as it were, been taken over or subsumed by the Constitution, but these rules still serve as a guide.
What is that, 1946?
Yes.
1940 and
1931.
41, when
Yes,
I was on the Q3 born.
They were approved at a conference in Cape Town in 1931.
Yeah.
And the writer Himstra describes the purpose as follows. He says, these rules are administrative directives for the guidance of the police force. And he says, the judges' rules are mainly of historical interest because they are longer in effect. Their role having to a large extent been taken over by the norms in the Constitution. The following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in Section 35, which distinguishes between an arrested person and a detained person. And Section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against that person. So if one looks, once again, my Lord, this buttresses the point that we are of the view that in this instance, one cannot really say that the accused made a statement, because if one looks at subparagraph C, says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in Section 35(2) pertaining to a detained person. And in this instance, the detained person also includes a suspect who's in custody, as it was held in the Sibajan case. But to come back to the judge's rule, rule number 8 says the caution to be administered to a person, in other words, that he's got a right to not to make a statement and what the consequences thereof is or are, says the caution to be administered to a person in custody should be to the following effect. And the rules distinguish between a person who's formally charged and a person who's not formally charged. In the case where a person is formally charged, it says, do you wish to say anything in answer to the charge? You are not obliged to do so, but whatever you say will be taken down in writing and may be used in evidence. And we submit, my Lord, that this is what this form caters for. And paragraph B says, where a prisoner volunteers a statement otherwise than on a formal charge. In other words, in this instance that we're busy with, if the accused volunteered a statement, and here the judge's rule refers to a statement, where a prisoner volunteers a statement otherwise than on a formal charge, the warning that should be administered should be to the following effect. Before you say anything, I must tell you that you are not obliged to do so, but whatever you say will be taken down in writing and may be given in evidence. We submit, my Lord, that what we are currently seized with, it's not a statement, it's just a mere explanation, an alibi that the accused gave that he was at work on the particular day, which was subsequently followed. And we submit, therefore, my Lord, that this form that my learned friend wishes to make use of is irrelevant, purely on the basis of evidence and should not be used.
Yes, thanks. Yes, Mshololo, you can continue.
Should I
My Lord,
continue?
Yes.
I see the witnesses.
Oh, okay. You want to talk to Mr. Baloi?
No, le kgopela go addressa kgoro pele Mamsholola a bolela.
I was asking to address the court before the defense asked a question. There is something that is bothering me, my Lord.
Okay.
Mabane gore go pe jore ke tlele pampiri ya di case e re dira mabane.
Yes.
Yesterday, the court asked me to bring a document of cases that we were doing.
So inkantolo ethele ukuthi ize namakesi la besebenza nawo izo.
Ke kelele tsona ka re leng khopetse.
I brought the documents as the court has asked me.
Ngize nawo ke njengoba bese ngiceliwe.
Ke ngwetse ka mokamelato e be re dira le mabitso a batho ka mogare.
I've written down all the cases that we were doing and the names of the accused.
Ngifale wonke amacala ngasimbhala namagama abantu abasolwa.
Ome ke file advocate Baloyi ka envelope.
I also gave it to Advocate Baloyi contained in an envelope.
Bese ngwanika Advocate Baloyi ngenvelope.
Ara ke dutse mo re tshere break.
As we were sitting and during the break, my lord,
Njengoba sihleli la sithathe ikhefu.
Ke bone pampiri jwa e ngwetse confidential e ke le fa yona.
I saw the document. When I handed it over to Mr. Baloyi, it was written confidential.
Bese nginike kwaBaloyi ibhaliwe ukuthi ke iyimfihlo.
Mara ke bona ba re tshetse kitima mo matlhong a batho ba ntšhi mo.
However, I saw the document now roaming around in court, my lord.
Who else had that document?
Ke mang ye mongwe e leng gore o bile le yona?
Le bone Muzi na iswere ba sora ka moga ba ne ba e bala.
I saw Muzi in possession of it and all the accused were reading it.
Ngone umuze iphethe ngibone nabanye abasolwa beyifunda.
Who gave them that? Do you know?
Le a tseba gore ke mang o ba fileng yona?
A ke tsebe.
Wait. Let him have his say. Who gave it to?
Le a tseba gore ba filwe ke bo mang?
Bona ba nikile.
A ke tsebe ba file ke ba.
I do not know who gave it to them, my lord.
Angazi ba nikuba.
And well ke kwa ke tshogela dihlatse tša rena tša mo melatong eo.
And now I am being worried, my lord, for our witnesses, especially in those cases.
Manje sengisabela ke abe ofakazi kuyo lamacala.
And e ke botša kgoro gape melato e mengwe eo e ama baswariwa ba bangwe ka swabitše ka mabitso.
And some of those cases also affect some of the accused. I would not mention them by names.
Enye ke lamacala thina abanye abasolwa ngeke ngibabize ngamagama.
Ka gore bjale melato e ka moka o nkga sethunya ka magare ga ona.
And in all these cases, my lord, there are firearms that are involved.
Manje ke lamacala kunanesibhamu esikhona lapha.
Batho ba thuntšitšwe,
People were shot,
Kunabantu abadutshulwa.
batho ba utswitšwe,
people were kidnapped,
Kunabantu ababanjwa.
ba bangwe ba threateniša.
and other people were threatened.
Kona ke abasatshiswa.
And be ke tshogela gore na re tlhatse tša ka re tla tsoga re sa phela go sasana.
So I was worried if my witnesses would still be alive tomorrow.
Manje sabela ukuthi abafakazi bami bazobe besaphila yini kusasa.
E ke bolela bjalo go na le di-case number tše dintšhi mo.
As I am saying that, my lord, there are a couple of case numbers there.
Manjalo khona ke amacala amaningi ke inombolo zayo sikhona lapho.
And go kgonagala gore ba tsene mo computing system ya rena, computer system ya rena ya SABC gore ba kgone go kry-a mabitso le di-address tša dihlatse tša rena.
It is possible that they can go into our SAPS computers so that they would get the names and the addresses of our witnesses.
Bangakwazi bangene kuma-computer ethu ase-SAPS ukuthi bakwazi ukuthola amakheli namagama abantu.
Go bolela bjalo a ya gore ke mo phara ka molato. Advocate Mogwemezulu o tle le pampile gore o ntšhitše mo systemeng ya rena ka case ya Nongoma.
I saw saying I am not accusing Advocate Ngomezulu, but he brought a certain case which he got into our system of a Nongoma case.
Ngithi sikicala ukuthi Advocate Ngomezulu nephepha ayalikhiphe kule case yethu yakwaNongoma.
E bontšha moswari wa mathomo.
And it shows accused number 1.
Ikhombisa umsolo wokuqala.
And mo godimo motho wa montšheditšang yone ke bone ngwetse Sergeant Ngomezulu a ke tse nna ke leloko la ga bona.
On top, it shows that a person that has retrieved that case is Sergeant Ngomezulu. I'm not sure if is that sergeant related to him or not.
Manje laphezulu ubhalwe Sergeant Ngomezulu angazi ke noma owakubona.
Bjalo ke kwa ke tšho gore na ba bangwe ba ka se kgone go ntšha information eo ka mokgwa yona e kry-ileng ka gona na.
So thus I am afraid, my lord, that will others not be able to retrieve the same information as he received it as well.
manje sengiyasibuza ukuthi laba abanye ngeke bakwazi yini ukukhipha-ke lo ntwazi ngale ndlela naye alikhiphe ngayo.
Be go bala botšhago gore na nako ke tla le pampiri e be e le ya baemedi or e be e le ya baswari ba na.
And I would also like to ask, when I brought that document, was it for the defense or was it for the accused?
Manje ngiyabuza ukuthi njengoba bengilethe le maphepha la abe abamaloya noma abeqondisiwe kubasona yini.
It was for the court. Actually, I'm shocked. I'm shocked. Because that document is supposed to be perused by me first. Because I'm aware of the Intelligence Act that certain documents are classified. I'm aware of it. I've dealt with cases like this in the past. When apartheid was applicable, where you approach a judge in chambers and the judge makes an order and reads it in chambers to the presiding advocates. But because we are so-called in a new dispensation of transparency, I made it in open court. But that document, or those documents, are not supposed to be seen by anybody except me, first.
Khotla e re e maketse go bana ditokomane tse ba di tshwanetse di bonwe ke khotla pele ka lebaka la gore ya tseba gore mo melatong e mongwe o sa le gwa diragala eng gape ga di jwale ke gore re se re le mo eleng gore re lokologile dilo di kgona go diraga ka tsela e leng gore ga se ka matshwanedi e pia khotla e re ditokomane tse di be di tshwanetse di bonwe ke khotla pele lapile e be le gore e tlatla e di balla baemedi ka bua kantorong ya moatlhodi.
Are you with me?
E ka kwishe be re nya go fetiša mo go tlhalosetsa gore botsebotse
No.
pampiri e be le ya go fa mang.
And I was trying to avoid a situation where in South Africa people and judges are accused of being bought, being captured and all that nonsense.
Khotla e re yona e fitlhetse mo karolong e leng gore e lapile gore di-judge le batho ba ka tla ba pharwa ka melato ya gore ba rekilwe go ba bona ba dira bo manager bo borileng.
And I was going to familiarize myself with that information, having regards to the Intelligence Act and protocols.
Khotla e re e be itlotse ya ditokomane tsewe e di bale e lebelele gape le gore e re molao o reng gape le tshireletso yona e reng.
And I would have decided what information, having regard to the proceedings here, has to be divulged to the councils here.
Ka moraga mo bua khotla e be itlotse ya sephetho sa gore ke tse di feng tse leng gore di swanetse di fiwe batho go ba baemedi le motšhotšhisi ka moraga
Are you with me, sir?
le a kwešiša. That is understood.
Mr. Baloyi, what is your excuse?
There's a good case, my lord. The document was disclosed to my colleagues in line with what the court said yesterday, that it's only meant for the eyes of the court as well as the defense counsel.
No, but they say the accused were reading it.
Yes, well,
They got it obviously from the...
yes.
Actually, I'm shocked, that senior counsels like this can actually behave in this matter. I'm just shocked. I explicitly said it's only for the court officials. Now you're telling me the accused are having... This gentleman is right when he says he doesn't know whether tomorrow some of the witnesses will be dead or not. Because this is, unfortunately, is a type of case we are dealing with, unfortunately, where people are said to be shot, etc., etc., etc.
But I've just asked my learned friend to give back the copies to minimize the impact that there might be, and the copies will then be...
Mr. Gumezulu, what's your view now?
My lord, I would like to exonerate myself from...
Hello?
I would like to exonerate myself. I've never consulted with the clients or with the accused.
Where did your clients get the document? Already?
No.
Which client and which accused?
Muzi le ka mogala wa ne ba kgobakanetse mara ba e lebeletse ka mo ba le tshwere pampiri jo ka mo.
Muzi and all of them, they were...
Who is Muzi? Accused number who?
Muzi
is number 1.
Accused number 1, my lord.
He was reading that document.
We tsera go ba kopana ba e lebeletse.
He took it and he went towards them and they were all together reading the document.
Yeah. And Mr. Nisi?
My Lord, I feel a bit uncomfortable when the court says,
Yeah.
and I'm saying this with utter respect for the court, when the court says the court is shocked that senior counsel such as us here
If it's true,
we do
Yeah,
such
you're
a
right.
despicable
Make a
thing.
mistake.
It is
If-
indeed despicable. my
if it
Lord.
is true,
Yes. But what worries me is I don't think a statement that has been uttered by the court in the circumstances where it has not been determined exactly what the circumstances were through which this accused person were able to say that document. It's a bit appropriate, man, because now it seems as if all of us they just decided to stand up and give these documents to
no, fine. You can tell me.
Coming
Is your
to the
client,
accused.
did your client see that document? Because that's,
I did not consult with my client this morning.
did
man,
he
but
see? You don't know if he saw the document.
I don't know whether
Okay,
he saw the
fine.
document
Mr.
or what.
Nimalo?
My Lord, I'm not too sure. Why is this witness worried about the statement that he has made? Because in his own statement that he made on the 25th of October 2023, he refers to one of the cases where
Now that's obfuscation. Do you know that word? Obfuscation. Hello? Do you know obfuscation?
I'll have to go to the dictionary.
OBFUSFUCATION. Obfuscation. That's what you're doing. We're dealing with the present situation. You're telling me about an affidavit of a person who you say.
No,
We're talking about a court order which said he must bring that information and it mustn't be made available to any other persons except myself maybe and
Then-
the council. Now you're talking about,
Yes. Then in that information that he provided, in his statement, I'm saying in his statement, he refers to one of the cases that are detailed in that document that he provided to my colleague this morning. One of the cases are referred there in his own statement that he made. So I'm failing to understand, my Lord, how I have
you
not-
don't even know what cases he's referring to in the document which he wrote. Maybe the very case you are quoting is not of any moment according to him. Are you with me? It's like the Nongoma case. You can mention it because we have dealt with it.
My Lord, the court is not understanding what I'm saying.
I understand fully, sir. So did your client have access to that document, sir?
I did.
This court. Hello?
I did consult with my client.
And you
based
showed him
on-
the document.
I consulted him based on one case that is mentioned in that
Sir,
document.
did your client have access to the document which I said the sergeant should write for my own perusal?
Yes, he did, because I had to consult with my client based on the case that the witness has documented in his own affidavit. The consultation was based on that.
Ms. Mshololo, what's your view?
My Lord, may I ask back leave to consult with my client because I personally have not read that information.
You are not aware of that information.
Of that information, but may I just clarify from my client if he?
Yeah.
Thank you. Thank you, my Lord, for the indulgence. My Lord, I have not read or consulted with my client regarding the document that was given to us by the state. And my client informs me that when they were grouped together with accused number 2, 4, and 5, they were reading this document, my Lord. Or maybe if I can just show it to
It's
my
not the
lady.
one that is prepared by.
It's not the one, my lord, yes. And they are indicating the page that they were looking for. Where
Whose
it
document is that?
It's an indictment, my lord.
Oh, they were reading the charge sheet.
They were reading the charges. They
Which
were
they've been
discussing-
reading the past 5 years.
No, my lord, but that's what
No,
was
I
happening.
hear you.
Yes, yes. This
Where's that confidential document, Mr.?
The document
Because
they were
now
reading?
we're getting
Yes.
the fact that now.
Sorry, my lord, can I just get further instructions, my lord? I see the hand is up from my client.
Yeah.
Thank you. My lord, just to add, my lord, as to what were they discussing in this indictment, my lord. He says they were discussing about witness number 104, who is being referred.
Now they can discuss their indictment, no
Their
problem.
indict-
There's
yes,
no problem.
ma'am. I just wanted to be clear
fine, I appreciate
as to
that.
what is it that they were discussing in
This
this
inquiry is about whether or not this order which I made has been exposed.
Yes, my lord. Those are my submissions.
Mr. Malloy, where's that document which you given by?
I'm just trying to get all the copies from my colleagues.
My lord, before the copies are being taken back, with due respect, my lord.
I want the copies which the gentleman, the witness, made to be put in the same envelope which was supposed to be for my eyes first. You know, during apartheid, I must say this, we had apartheid judges in these treason trial cases where a judge would make an order that an investigating officer should do what I did. And then he would say that the order is just for the court. And even the counsels who were in court would never ever be aware of that order, because the judge then had a discretion whether to disclose that information or not. And invariably, he never disclosed that information. Now, we think we've got a democracy here which is functioning. And then court officials will know what to respect when a judge says that order is made to divulge certain information which is not supposed to be made available to the public. Just check whether all these documents are the ones which you... Do you have a copy of the original document?
copy ya original ya tsona.
No, ke di file ntate Baloyi, ke mo file
How many?
Le ba file tse kae?
file ntate Baloyi original document.
I gave Mr. Baloyi the original document
Ena itirela copy.
and he made copies for himself.
So there was one document.
The document yet.
So nna ke na yona, ke dira ntirele yona.
Okay.
I do not have it. I said he should do it for me.
Is it Gininda who will know, just listen to me, is it Brigadier Gininda who will know under which section of the Intelligence Secrets Act these documents are categorized?
Le go tlo kgonagala gore le tsebe gore di-document tše di mo sectioning e feng.
Ke tseba ke dirinda gore le di mo Secret Service le Crime Intelligence.
I am informed that they are on the Secret Service and Crime Intelligence.
Okay, can you bring those documents?
Sure.
In the nature of things, these documents are not going to form part of these proceedings because that evidence has now been contaminated. And this court has got a discretion to decide whether to make these documents available as I originally intended. Because from what this witness is telling me, if I do that, some people's lives will be jeopardized. It's not saying that. He talks about people being killed. He talks about guns swirling around. He talks about kidnapping. He talks about whether his witnesses will be safe and alive tomorrow. So this court makes a ruling that this information must be expunged from the record of these proceedings on the basis of the fact that it may jeopardize other persons' lives, which are more important than the life of this judge. Okay, Ms. Michelle, let's go on.
My Lord, can I ask that we take the long adjournment and now resume after lunch?
Okay. What's the time there?
I think it's 2 minutes after 1. My Lord, we're debating the issue. Is counsel now going to proceed?
Yeah, I'm going to proceed with the cross-examination.
Along the lines that she was doing.
Yes. But the only order I made is that this confidential information
Khoro e re ditokomane tsela tse le ba fileng tsona ga di jwale khoro e tlilo di swara ka lebaka la mabaka a besitseng le fane ka ona e be go bolelwa ka maphelo a batho.
bonke labaphephabetele ukuthi usayitshele walethela enkantolo ukuthi azochitha enkantolo ayasasetshenziswa kulolu daba.
just for my own edification. Where are the dockets?
Di docket di kae?
Docket ya Fosloras. Since ba isha decision I so
Case number?
Di case number e feng?
534.
Aksa go pola case number.
What's the charge? What's the charge?
Yeah.
Molato wa bona be di
And for dealing in drugs.
dealing in drugs, my lord.
Yeah, it's 534 if I recall. 534
Something, yeah.
of 6.
Khoro e re e ka re ke 5346.
And the other one?
Yengwe.
Ekia Nongoma 163 of 10
And this one it's for Nongoma 160
of 10 2018.
of 10
160
2018.
of 10, 2018.
Yes.
Where is the docket?
E ka yo.
Normally ke shila ke ikere my lord because Kenel Ginda we will some rotla tla ilebella.
I
Okay.
did not get it where I left it, as Colonel Ginda said he will come and look for it.
And the other one?
Yengwe guy.
No kutshwana tse pedi tse bele nokea.
Those are the two that the court needed.
Okay, 2 o'clock.
My Lord, can I make one submission, my Lord, with due respect? I know the court has ruled, but it is my request that that information that has been taken back from us, it must not also be kept with the court,
Why not?
because that information is coming from the witness.
Did you hear the ruling I made?
Yes, my Lord.
What was the ruling?
That we are not entitled to it. The order was that the witness must bring this information for the court purposes.
Right.
Yes, my Lord. My request, my Lord, is that the information cannot come from the witness direct to the court without us having been given an opportunity to look at the information that is submitted before this honorable.
I thought you had seen it, all of you. You just gave a copy. Didn't you give a copy?
I have not seen it, my Lord.
Okay, take
I
it.
have not seen it, my Lord. Thank you.
This information will form part of the proceedings of this. Just give it.
As the court
So that
visits,
if this case goes somewhere else, the
As-
judges in the SCA,
SCA.
and the judges in the Constitutional Court
Thank
will have
you.
access to this.
as the court visits.
I'm not so naive as to take the information which has been led to this court and go and keep it in my sitting room.
Thank you, ma'am.
Jwacho ba khopela gore ditokomane tsela di ska ya thuto khoro le ka wa
I now they're trying to where is that order?
Sorry,
Mr. Shalom,
Sorry, my lord.
where is the order which I handed over to you?
Order.
The document you said it can't go from the witness to the court. So, Mr. Balui, you made how many copies?
Enough copies just for
Yeah, but in other words, how many copies did you get? Is it 1 copy or 2 or 3?
we got all the copies back.
No, you're not listening.
Yes, sir.
This witness, how many copies? Let's say, how many pages of the order I said he must give us the information on? How many did he make?
2.
When said the copy second, how many copies did you make?
There was only one.
1 copy.
One copy, madam. And
Okay.
8, just enough for council.
Right. So every council has got that order, eh? And every client has read it. Mr. Mkomazeli, the client read it also.
Not.
This witness says he read it. Said, are you saying you saw even number 1 reading it? And number 2?
Number 1.
He was sitting together with him, but I'm not sure if
And
he
number
was.
3?
ntho a dirileng o tlogele mo ka pampiro a kopana le bale kwa ba e lebelela ka mo
All 5 of
Number
them.
1 went to the group, my lord, and they looked at it together.
All 5 of them.
Ka mo ka bale ba batlhano, correct?
Can you give all 5 of them copies? Copies so that I just read what the law requires. Mr. Baloi, can you give each and every accused that order which was supposed to be made for this court, which has now been publicized?
We will make them copies.
Now give them now. I want to see them getting it.
Well, we only made enough for council. We'll have to make extra copies now.
Councils have got all copies. Mr. Ngomezulu, do you have a copy of that order?
This is the copy.
Do you have a copy?
No, I'm about to receive a copy now.
Mr. Mnisi, do you have a copy?
We thought we needed to take them back, madam, but now they have been returned back.
No, you have to get copies, all of you.
As it is the court.
Mr. Numalo and Ms. Mishororo, you all have copies.
Yes, I've just received it, madam. Thank you.
Yes, my lord, I've also just received it. Thank you.
Yeah, it originally ruled that that order must be expunged. But after having consulted authorities, in terms of our law, there's what we call a posterior ruling, a statement. And Black's Law Dictionary, the 10th edition, defines it as such. A formal statement endorsed on the trial record. That's what I'm doing. I'm endorsing this order, which I thought it's going to be confidential, on the trial record. Giving an accurate account of the proceedings at the trial, which I hope I've done. A record of what occurred at Nisi Prius after the issue had been joined. The issue was joined on the basis that when this witness, Sergeant Mohanene,
yes my lord
was being cross-examined, he repeatedly said he's unable to divulge the information regarding the investigations of the cases which you say accused number 1 or 2 or the others they're involved in, because you would be revealing confidential information. Am I quoting you correctly?
Ke nnete gore kgoro e re lena le rile go na le dilo tse e leng gore ga le kgone go di bolela ka lebaka la gore go na le ba bangwe ba ba latofatswa ba e leng gore ba gona go melato e nngwe gape le tlabe le ntšha dilo tse e leng gore ke diphiri ka sewe sebaka.
ke nnete
It is correctly quoted, my lord.
Yeah, because this court hopes to be fair. There was a dispute as to whether this witness is actually his testimony is actually the truth or not. And at that stage, this court is not involved in joining whether this witness is being truthful or not, because he's at the moment giving evidence. This court decided, in the interest of justice, that if it is actually correct that these cold cases he alludes to, including the Nongoma case regarding the murder, the court should make a request in the form of an order that this witness should itemize and categorize those cases in which he says they are cold and they are at the moment not yet finalized. Because it was put to him that, for instance, that Nongoma case was finalized, and he said, no, it's not finalized. And by that exigency, this court expected and hoped that this court will get the information which it will share with the accused counsels, that in fact, indeed, such cases are still being investigated. Is that not your evidence, sir?
Ga se botlhatse ba lena se kgoro e fetsa go se bolela ka dijwale gore di melato eo e santse e nyakishisha.
Ke nnete.
It is correct, my lord.
Consequently, that's why I made that order. And I was of the view that that order is made for the information of this court. And in terms of this posterior principle in our law, I was going to call all the counsels into my chambers and show them the confidential information which was divulged after being extracted by this witness from the various dockets. Because I believe that counsels are officers of this court before they are defenders of their accused. That's a sacrosanct principle of our law. You are officers of this court before you are defenders of the accused, because when you are admitted as counsels of this court, you take an oath to uphold the law practices of this court. So one would have expected that even if counsel informs their clients about the fact that in fact it is correct that there is proof that some of the cases which the gentleman is giving evidence on, saying they are cold but they have been resuscitated, in fact it is correct that those cases are being attended to. And I believe protocol dictates that not everything which this court divulges by intruding into the Official Secrets Act. And if counsels understand that exigency, you don't have to tell your client about the fact that they say one of the murderers there is Mokhatle, because you are enjoined to the privity of the information which has been divulged in this court, because this court has made an order that even if it is in terms of the Official Secrets Act that this witness was saying he can't divulge that information, but this court, using its inherent jurisdiction and Section 173 of the Constitution, as Mr. Minister likes saying, you can make use of that information under certain conditions. Okay. So consequently, if anybody wants to use that information, which has been so irregularly been divulged, you are at liberty to do so. And this principle starts from the 15th century, so that the must say, I did judge lay is a long church. With the verdict of the jury in the 15th and 16th centuries, the proceedings at Nice was closed, and the case was sent back to the court at Westminster, from which it was issued for judgment after a statement of the holding of the trial and the verdict that had been added to the record, as I'm doing. This statement, from the fact that it has begun with the Latin word postia, or afterwards, was known as the postia and was in fact drafted by the party in whose favor the verdict had gone. Whence the phrase postia to the plaintiff or the defendant, which is found in the old reports. You can see in this regard Geoffrey Ratcliffe and Geoffrey Cross, Legal Systems, England. It's a 6th edition textbook written by Bentley and Hand. It's the 6th edition, if you want to read about this any further, 1977. Okay. Yes, okay, Ms. Msholole, you can go ahead and cross-examine.
Just the court business. My Lord, before I resume with my cross-examination, can I just ask one thing on clarity, my Lord? So it means that on this document, I can read it but not share it with...
No,
my
it has already been shared. You can read it and share it with your clients. That's why I insisted that each of your clients should be given that document, so that it mustn't be said that this information which this court has withheld.
That's the court business. Thank you, my Lord.
Yeah, well.
Sergeant Mkhane, let's just go back where we paused yesterday. I'll try not to repeat myself, but we'll just wrap up somewhere there and there where I need clarity on those issues.
Mara ba lo tswela pele mo ile gore le shile gona maobane ge ile gore bona ga ba nyake le gore ba boele go tse ding tša dilo e fela ge ile gore bona ba hloka gore ba kwešiše dilo tše di rileng ba tlo le buša ka tsona le ya kwešiše.
Ka kwešiša.
That is understood.
Lesubela emuva kuloko esifunde ebesikhuluma ngakho izona ngesiqede konke kodwa kunezinto ezifanele zicacishwe.
For the sake of progress, you remember we were talking about the interview that took place at the boardroom.
Gore re tswela pele jwatse le ya gopola gore be re bolela ka poledišano ye diragetseng ka boardroom.
Ngiyakhumbula
Yes.
esikhuluma ngale kwakhulunywa e-boardroom athi yebo.
I'll just ask one question in that regard and then move on in that aspect.
Ba tla botšiša potšo e tere ka yona tabewe ye be le gore bona ba tswelela pele.
Kushuthi uzobuza umbuzo owodwa nje kuloko bese siqhubeka phambili.
I am listening.
The interview that took place between yourself and other members and the suspect was not recorded.
Interview yela ye leng gore lena le be le gona le ba bangwe ba be leng gore le be le tshana le bona be se e recordiwe ga se gatišiwe felo tsoko. Correct?
Manje lokhu ename kukhuluma wena nalabo abanye azange kuqoshwe phansi okuhlala.
Okay. If I can just take you back, also I just need confirmation. When you firstly approach accused number 2, when you arrested him, you explained to him the allegations in respect of the Nongoma case. Am I correct?
Ge le ya go molatofatšwa wa bobedi la mathomo le ile lena la mmotša ka molato ola wa Nongoma. Correct?
Manje uqala kumsolo nafike namtshela ukuthi usolwa ngani mayelana neNongoma athi yena.
Okay. And then when you were charging him,
Ge be le mo rwesha melato
then which allegations did you refer to him?
le mmoditše ka gore lena le mo rwesha melato ka eng.
Manje basekele nizomtho siqala belithe ukuthi mtho seliqala ngalini.
Le ka tlhaloša le bolela ka isale ka June.
Can you please explain further? Are you referring to the month of June?
Yeah, the month of June. You have arrested him from his house. And then you explain the allegations in respect of Nongoma case. Correct?
Ke re le mo swere ntlong ya gagwe. It is correct.
Yes. And then you took him to the station.
La Misha Spodise. That is correct.
Namthatha namisa esiphoyiseni athi yebo.
Wherein he was charged and detained.
Ke mo ba ileng ba mo rwesha melato la mo tshwara. That is correct.
Ayitshela amacala akhe waseyavalelwa athi yebo.
Yes, at that time when you charged and detained him, which allegations did you explain to him? Was it in respect of Nongoma case or in respect of this case, Foster's case 636?
Ge ne le mo tswallelela le be le mmoditše ka melato e mefeng le mmoditše ka wola wa Nongoma goba le be le mmotša ka wo wa Foster's.
Manje basenze umvalela amtshele ngaleli icala ela kwaNongoma nona nimtshele ukuthi unecala lelaseflosloras.
Remoditše ka molato wa Nongoma.
We informed him about the Nongoma case.
Samtshela ngecala kwaNongoma.
Okay. So, then on the following day when you booked him out, you then interrogated him on the Foster's case 636 and not Nongoma case.
Letšatši le latelang ge be le montšha le do mmotšiša dipotšišo le ile la mo phama dipotšišo ka molato ola wa Nongoma e seng wa Foster's.
Re thomile pele ka Nongoma then ra latela ka Phosphorus.
We firstly interrogated him on the Nongoma case and then followed up with the Phosphorus case.
Ngilandelayo kuma sikhifa na ke nakhuluma ngecala labanongoma noma lesephosphorus athi asaqala lesephosphorus sesiqhubekele nalawo nongoma.
And then in respect of this phosphorus case 636, the accused number 2 denied any involvement in this case. Am I correct?
Molatofatso wa bobedi ka molato wa Phosphorus 636 yena o ile a ganela gore ga senke ya ya karolo ya molato o ke nnete. It is correct.
Waphika umsola ngithi kule icala lesephosphorus ukuthi yanaso wathi akanaso yena kunjani.
And then, in respect of the Nongoma case, if I remember very well your response yesterday, he was never taken to court for his first appearance at all.
Ka molato wa Nongoma ge ba gopola botlhatsi ba lena ba maobane lena le rile ga senke a ishiwa kgorong.
Hello pitsa ga botse. Me re mishitse kgorong, go me re fitla kgorong Chutisarno ka gore le Nongoma e a se jurisdiction ya gagwe. And then la ba re mmisha ka ya Phosphorus.
If you would recall properly, we took him to court and the prosecutor said this Nongoma case, it's not under their jurisdiction. Then that's when we had taken him for the Phosphorus case.
Yeah.
Must which is sometimes isiyobuza ngecala la kodwa ke masifika lapho kusho ukuthi Nongoma ke ayike ezandleni zakhe saseke siqhubeka ngecala leSophosphorus.
Yes, but in essence, he was never taken to Nongoma court for his first appearance or for his appearance under that case. After the prosecutor has said that it does not have jurisdiction over Nongoma case.
Kamra ga gore motšhotšhisi a re yena yela ya Nongoma ga e ka fase ga jurisdiction ya gagwe ke mo e leng gore yena a senke a tswelele pele ga kgorotsheko ye e rileng ka molato wa Nongoma. It is correct.
Uqala la Nongoma umthuthisi sethe alike ezandleni zakhe akazi ayise enkantolo ngecala la Nongoma wathi yena.
Okay, so it means Sergeant Mohane on the 19th, I suppose we are on the same page that you saw the prosecutor on the 19th of June.
Le a dumela gore le bone motšhotšhisi ka di 19 tša June. That is correct.
So it means on the 19th of June, when the accused was not taken for his first appearance, the 48-hour rule expired in respect of Nongoma case, since he was never taken to Nongoma court for his first appearance in that case.
Gora gore jwalo ka ga lena le bone motšhotšhisi ka di 19 ke ge e le gore ge molatofatso wa basare yena a tsena ka kgorotshekelo ke mo e leng gore di hour tšela tše masomenne seswai bese di expirerile ka molatong ola wa Nongoma.
Manje njengoba yena ngamisanga enkantolo mayelana necala kaNongoma usho ukuthi ke la mahora amashumi amane nesishiyagalombili usho ukuthi ayeseqile mayelana necala kaNongoma.
No, we saw expired.
No, the 48 hours had not yet expired.
Okay. It's fine, I'll leave it for argument. Let's continue. You then, on the same day, on the 19th, when accused was not taken to Nongoma court for his appearance, in Phosphorus, his case was not enrolled, and he was supposed to be released. Am I correct?
Jwalo ka ga lena le re ka di 19 tšhekong yela ya Nongoma ga se a ye go dula go yona go ra gore yela ya Phosphorus o be swanetše molato wa gagwe o tšhollwe go jwalo. That is correct.
Ngoba ke azange ngene icala lena kaNongoma usho ukuthi ke icala leSophosphorus lalifanele lichithwe ngaphandle ebese yakhululwa umsolo athi kunjani.
And he was not released. Am I correct? According to the exhibits that we have read into this court.
Go ya ka botlhatsi bo lena le bo badileng mo kgotla tshekelo lena ga senke le molokolo le molatofatso.
Kodwa ngizange nimkhulule ngala maphepha phambi kwethu.
And a further,
correct.
a further detention after there was an endorsement that the accused must be released was unlawful because you did not have any warrant of arrest to arrest the accused on any other further or subsequent cases that you were investigating.
Se se bolelang gore lena le tswele pele le moswere besitse go le ka ntle ga molao ka lebaka la gore le be le sena tokomane ye be le dumella gore lena le be le ka moswara go ba le ka motswallela nako e nngwe e fetang eo.
No, but it's a J50.
It was not unlawful, however, we did not have a J50.
Thank you for that.
Manje-ke ukuthi uqhubeka ke avalele umsolo usho ungasekho emthethweni ngoba nani nazo incwadi zokuthi ningamvalela ngalama yebo kodwa ke sesingaya J50.
Yes, at that time when you did not have a J50 authorizing you to detain accused number 2 further after his matter had not been enrolled in forced arrest, you took him further for further investigation. Am I correct?
Ora gore jwalo ka ga le be le sena yona J50 yela lena molatofatswa le ile la motšea le ge ile gore le be le sena tokelo ya gore lena le ka moswarella lena la motšea le ilo mmotšiša dipotšišo le ilo nyakišiša. It is correct.
Bathi njengoba nani ngenayo J50 kodwa na vele namthatha umsolo naqhubeka ukwenza uphenyo athi yebo.
Okay. And am I correct to say after forced arrest court, when he was detained around 1339, you recall me if I'm quoting the time wrong, it was 1339. From 1339 up to the time when he was detained at Pukeng police station, you had no warrant of arrest in your possession to keep the accused in your possession.
Ora gore lena go tlogelle nako yela ba re le tla ba phosholla ge le gore nako ga se ba e be ga botse nako yela ya 1339 go fitlhella le be le ilo mo tswallela ka kwa ka police station ya Phuket ra gore lena le be le sena tutukelo tša gore le be le ka moswara.
Iqiniso ukuthi lapha ePretoria sona isikhathi ka 1339 ikofika isikhathi navala ngaso ephukeni ngenalo igwelo ukuthi ngabane mbambile wathi.
Okay. If I also recall your examination in chief, the reason for you to take accused number 2 to his house is because you wanted to check the hoodie that he was wearing.
Ke botlatse ba lena na gore ge be le motšea le misha ntlong ya ga mo be a dula gona
When-
le
when-
nyaka go ilo bona ke fa ele be ya pele.
When the incident in the forced arrest case 636 took place.
Mo be leng gore
Am I correct?
molatola wa forced arrest case 636 o be o diragetse gona.
A ke le kwešiše le ka boeletša gape ke leko e botse.
I do not understand. Can you please rephrase so that I will be able to understand correctly?
Okay, thank you. I'll repeat. And if I'm correct from what you said, your evidence before this court, you said the main reason you did not release the accused from forced arrest court and proceeded to his house because it was because you wanted to go and search for the hoodie which was worn by the suspect on the date when the incident took place under case 636, which we are dealing with in this matter.
Le rile lebaka le le dirileng gore lena le ska tala molokolla ke ka lebaka la gore lena le be le nyaka go misha ntlong mo be a dula gona gore le ilo lebella hudi go ba ke fa yela ye leng gore ba ere ka tšatši le be go diragala molato wa forced arrest case 636 ye re bolelang ka yona ya mo.
Kusho ukuthi isizathu sokuthi ningamekhulule emva kwase-forced arrest ukuthi nanifuna ukuya endlini yakhe ukuthi niyohlola ukuthi ningayithola yini le hoodie yayigqokwe umsola kuleli cala lase-forced arrest 636 kunjani?
Ka ge re sa kgobeketša bohlatse bja 636 ke nnete.
Yes, as we were still gathering evidence for the case 636, he is correct.
Okay.
Yebo kunjalo ngoba ngalesikhathi sasazama ukuhlanganisa ubufakazi obungasiza kuleli cala lika-636.
Is it also your evidence that in 6 years' time, from 2014, 15, 16, 17, 18, 19, 20, 6 years later, you proceeded to accuse number 2's house with an intention to search and seize when you did not have a warrant, a search warrant in your possession in respect of the case or in respect of the information that you wanted to search and seize.
Ke nnete gore lena mo mengwageng e etshela le bentse le nyaka go ilo tswella pele le ilo lebella le ilo tlhola kwa ga gabo goba mo be a dula gona le ge e le gore lena le be le sena dipampiri tse e leng gore di be di le dumella gore le kae le ilo searcha
Mhlawumbe kwaminyaka eyisithupha nasuka nami zina kamsolo sibili ukuthi niyohlola noma niyowenza uphenyo noma ukuyosesha ningenayo i-warrant nalezi ukuthi niyozithola lapha kuyani.
Ge le ka gopola botse molato a so thome ke rena mathomo for 2014.
If you would remember properly, this matter, we are not the first investigators since 2014.
Mangakhumbula kahle thina ukuqala ukuthi siphenye lolu cala kusukela ngo-2014.
Go fitile matsogo a mantši kudu go fitlhela rena ba re fa ona.
There are many investigating officers that has worked on this case until it was brought to our attention.
Baningi abaphenye leli cala lapho-ke izolethwa kwe-ET.
Rena ro hweritše molato ka December 2019.
We got this matter in December 2019.
Thina sathola leli cala ngo-December 2019.
Okay. Thank you for that explanation. But I don't have a problem with how many members who have investigated this case. That's not my question. That's not where I'm going to. Whether you were the 15th or the 30th member to investigate this case. But on the 19th of June, when you went to search in accused number 2's house, you were not in possession. You did not have a search warrant authorizing you to go and search the item that was worn by accused 6 years back. That's my question.
Ape ba leboga le gore le nna le ba botse gore ga se lena ba mathomo ba go bereka go molato eupia selo se ba se bolelang ba re ka di 19 kgweding ela ya botshela lena le be le sena ditokomane tse e leng gore di be di le dumella gore le ka sepela le ilo nyakishisha ka mola ntlong ntho e leng gore molatofatša o be a e apere mengwaga ye tshela e fitileng
Kuzothi kusho ngomhlaka 19 kuJune angiphethe warrant ukuthi niyosesha lapha endlela yamsola ifuna lezi kuthiwa zazigqoke sola ile minyaka esithupha eyadlula.
Go na le molaotsoko ka mogare ga Criminal Procedure Act o re dumelelago go swara ebile le go searcha re sena warrant ebile gore a ke sa gopola ke tla ile go lebelela gore na gore molaotsoko.
There is a certain law in the Criminal Procedure Act, even though I would not recall which section refers to that. However, I will go and search for it, which allows us to arrest and search a place even without a warrant of arrest.
Yeah, no,
or a search warrant.
Umela ukuthi singasiyosesha nanoma singenayo i-warrant seziyofuna lo mthetho ukuthi ikhona lo mthetho.
No, thank you for that. Don't worry about that law. We'll argue about it before this court. The only confirmation that I want to get from you is whether did you have a search warrant or not.
Ba re le ska tshwenyega ka molato o bona ba tla o lebella gape ba tla ba boleishana ka ona gona mogoro. Lena, we did not have a search warrant.
That's all I wanted.
Singenayo i-search warrant.
That's all I wanted. And then you entered accused number 2's house and you searched and recovered the ammunition. If I'm not mistaken. Am I correct?
Le ile la tsena ntlong ya molatofatšwa wa bobedi la tlhola gana ka molala khumana dipule dikolo.
Ngangena lapha dinamsolo sibili nasesha ngigcina nithole iy'nhlamvu zesibhamu.
Ke nnete.
It is correct.
That is correct. Kunjalo.
And also you did not have the search warrant regarding any bullet or any firearm that you were looking for.
Le bentse le sena yona tokomane ela ya gore le search re be le ile khumana tsona dikolo tse.
Ngingenayo imvume yokuthi niyofuna iy'nhlamvu zesibhamu.
Nnete.
It is correct, so.
Okay.
kunjalo.
Thank you. Let's go back a little bit on the occurrence book. Since we have testified, maybe you can refer if you want, but I will remind you.
Ba re tlo boela morago go occurrence book ge ile gore lena le a nyaka le ka ya go yona fela ba tla le go quote.
Accused number 2 denied any involvement in respect of Foster's case 636 when you interviewed him in the boardroom on the 17th of June 2020.
Molatofatšo wa bobedi yena o ile a gana gore e be ile karolo ya molato wa Phosphorus case 636 ka di 17 tša June 2020.
So the hospital wa phe ukuthi yena uthinga le litala le 636 lo sephosphora in castle division ni lapha eboardroom mane mbuzo mbuzo. Kunjalo.
Ke nnete.
It is correct.
That was the first and genuine response given by accused number 2 when he was asked about this matter of Foster's case 636.
E be ile karabo ya gage e ya mathomo ya nnete ge be le motiša ka molato wa Phosphorus 636.
Kwaku impendulo yakhe yokuqala yophendulo mane mbuzo ngale litala 636.
Ge le re ya nnete le ra yang ka gore e tshwantse go be le phetolo ya mathomo re ya nnete a kusho le be le ya nnete le ra yang.
What do you mean when you are saying the first genuine response from him? Because we were expecting the first answer
Okay.
from him.
Let's move on. Let's move on. On the 18th of June, he was then booked out for the whole day on the 18th of June. You remember? At 8:15, as per serial number 520.
La gopola gore ka di 18 tša June.
That's the
yena
exhibit entry that you have read into this court.
o ile a tšewa ka 8:15.
He was
Yeah.
booked out at 8:15 and only detained at 2:30 in the morning.
Le mo tšere ka 8:15 yena a bušwa ka 2:30 e leng 2:30 ya matsha go ya ka mokgwa
Ke na yona mara ke tla ke a gopola.
Yeah.
I do not have it, however I do remember that.
Mka 18 kuJune wakhishwa ngo 8:15 kuyange ngale umbhalo lo bhalo to 520 wazobisa ngo 2 ekuseni.
Yes.
Yebo njalo kodwa anginawo ke lo mbhalo wona.
And then on the same day, on the 19th of June, at 2:35, the suspect was charged. You remember?
Ka lona tšatši leuwe
That
la
one.
di 19 tša June ka 2:35 ke mo e leng gore molatofatšwa o ile a rwešwa melato le ya gopola.
So then
Ya
I'm
gopola.
trying to
Yes, I do recall.
ngo 2:35 umsola ilapho katsho siqala yebo.
And early in the hours of the same day, 19 June, at 4:50, the suspect is booked out to Foster's court.
Le ya gopola gore ka masa ka tšona di 19 tša June ka 4:15 ya masa ke mo e leng gore molatofatšwa wa tšewa o išiwa kgorotshekelo ya Phosphorus.
Ngo 4:15 ngalelo langa umsolo wakhishwa enkundleni yamacala yasePhosphorus.
Ke nnete.
It is correct.
Yebo njalo.
And according to your examination in chief, when you were on your way, after you had booked out accused number 2, you were called by Colonel Gininda, who told you that accused number 2 wanted to make a statement. Am I correct?
Le ya gopola gore lena le rile ge le le mo tseleng ge e le gore le ile la khumana mogala go tswa go Colonel Gininda a le botsa gore le molatofatšwa o be a rile o nyaka go bolela ntho e rileng.
Ngisakhumbula ukuthi ke nathi sendleleni nathola ukuthi ngivela ku Colonel Gininda ethi ke umsola ufuna ukuyobhalisa ke i-statement esithize.
That's not the evidence I listened to.
Oh, sorry.
They got a message from Gininda to say, no longer go to
Court.
the court.
Yes.
Go to Morocco because I have now located a person who can take a confession. After Gininda had told them the previous day, told accused number 2, if the evidence of the sergeant is correct, that you don't have to make a confession or a statement before me. I'll find somebody to take your confession. Okay, that's the evidence.
Yes, my lord. Should I
Not
withdraw
that
the-
Ginida told them on the way to say the suspect wants to make a confession. No,
Okay.
they had
But,
already said that the previous day.
my lord, but the call was made in the morning when they were on their way to Foster's court
To say what?
to say that the accused must be taken to make a statement.
Yes.
Yes.
Not that he wants to make a statement. Because the arrangements were already made by Ginenda, in other words.
Thank you, my lord.
Yes.
Can I just proceed, my lord?
Yes,
with
do proceed.
the line of my questioning, because I'm now getting distracted.
You're not, Ms. Msololo. I'm quoting the correct record, what it says. You can ask Mr. Mgomezulu, am I confusing anything?
No, my lord,
Hello?
this is the correct.
Ms. Msololo was not there. I'm quoting the correct evidence. Now I'm being told I'm distracting.
Thank you, my lord.
Please.
My lord, can I proceed, my lord? My question is, why now, when the accused has been booked out from 8 o'clock up to 2:30, when he was booked back, now that he has changed his mind?
Ba re putso ya bona ba nyaka go tseba gore gobaneng jwa tje ge mo
Is a good please, my lord. I don't know why counsel says the accused has changed his mind. The court is just now put to counsel what the correct version is, that the incident started already the previous day on the 18th when they were in Carltonville, where he intimated that he would want to make a statement, and Brigadier Ginina then said he made arrangements. And on the 19th, he contacted the witness to say he has made arrangements. There's no change of mind.
Can I rephrase that question, my lord? Is it correct that the accused only indicated that he wanted to make the statement during the time when he was booked out for long hours, from 8:15 up to 2:30 in the morning, when he indicated that he wanted to make a statement?
a fa ke nnete gore molatofatswa yena o rile o nyaka go dira statement nako ela re ne ba mo tsere nako e telele o tlogelleng ka 8:15 go fitlhella ka 2:30 ke mo ileng gore o ile a re o nyaka go dira statement.
Once again, I don't know whether the part that says when he was booked out for long hours is correct, my lord, because the witness said it was around 4:30. So it was from 8:15 to 4:30 when he signaled his intention, when he made certain admissions, Lord, and arrangements were then made. I think the addition of long hours will not be correct.
Thank you, my lord. I'll leave it for argument, my lord. Can I just move on? Because the hours are indicated from the OB entries, my lord. Let's move on, Sergeant Mohane.
Mara taba ela ya di iri tse di telele ba tla e lesa ba tla e sheka bona ka bona ga ni jwale re tswela pele.
Is it also your evidence that when you were with accused number 2 in hospital or outside hospital, he was also asked about the involvement in the case of Foster's case 636?
Ke botlhatse ba lena na gore molatofatswa e rile ge be le na le yena ka ntle ga sepetlele.
On the 18th of June, when you booked him out and went to hospital or his place of employment,
Ka di 18 tša June ge be le mo putlile out le ile sepetlele goba mo be a šoma gona.
Ke mo be ga shoma gona since sepetlele.
It is not the hospital,
It's-
it is where he was working.
where he was working.
Wayefisha lokuthi ayela ayesenza khona ungekhona esibhedlela.
Thank you. And where he was working in hospital, you also had interview with the suspects.
Mo be a bereka gona le ile la kgona go boledišana gape le yena le ba le interview.
La esenza khona naye akwazi ukuphinde ngikhulume naye umsolo.
rapele or a vesher fedicci go check our level of America.
Are you saying before or after we had checked that was he at work or not?
No, at that time, at that time, I don't know according to your evidence, it can be before, it can be after, I don't know, but you were at his work employment at that time when you interviewed him.
Ba re ga ba tsebe gore be le ka pele go ba be se le ka morago fela re be le mo yena mo be a shuma gona.
Awazi ukuthi na ungaphambili noma ungemuva ukuthi iqedwe umsebenzi wenza license yakhona kodwa khona ingxoxo abanayo khona ngaleso sikhathi ni license yakhona.
Eke go pala gore ke rile Brigadier Gininda o re joinile le Sergeant Mogola.
But I remember it's that I said Brigadier Gininda joined us with Sergeant Mogola.
Mangu bodayo ngasho ukuthi Brigadier Gininda where's our Zoshana Natino Sergeant Mogola?
Yes, and then what happened?
And we were waiting for them at the gate outside the mine.
So swali de sangweni ngaphandle kwemine.
Gomme re Brigadier Gininda fihla le Sergeant Mogola ka introduce go Brigadier Gininda wa ke Sandy Sontanzio.
And when Brigadier Gininda came with Sergeant Mogola, I introduced him to the Brigadier that this was
Sandy Sontanzi.
Sandy Swa Ntanzi.
What you may figure out, Brigadier? No, Sergeant Mogola. I said, me too, get it. We are like it on a Sandy Sontanzi. Me too, go Brigadier Gininda.
Wela mochara re tlile go verify gore ka nnete go le mshomong na ka ge ke mmodi tša Brigadier.
And Brigadier said we are here to make sure whether were you indeed at work, as I had explained to the Brigadier.
Athi-ke hayi-ke ngiyachaza ukuthi hayi sidana nje ukuzothola isiqiniseko sokuthi-ke ngempela ukhona yini emsebenzini njengoba kuchaza kokhulunywa uBrigadier.
Ke polishano e re bileng le yona pele re tsena ka gare ga mine.
That is the conversation that we had before we went into the mine.
Yona ingxoxo esabanayo besingangena emayini.
Okay, in other words, at no stage wherein the accused was asked about his involvement in this case at that time.
Kana boye ga gona mo ileng go fatswa o ile a botsishiwa ka kamano ya gagwe go molato.
Futhi lapho akukho la umsola abuzwa khona ukuthi uthengeleka kanjani kuleli cala.
No, Brigadier lo ya mmotsisha after amu moritse ditokelo tša gagwe.
Brigadier asked him after he explained his rights to him.
uBrigadier wamtshela emva ukuthi wambuza emva ukuthi amchazeleke amalungelo akhe.
And were you present?
Lebelele gona.
Be ke le gona.
Yes, I was.
Wakhona thi yebo.
Okay. Did the accused respond?
Molato fatswa o ile a araba.
Sola waphendula.
A o ile a gomola.
He remained silent.
Uvele wathula.
And then on the 19th, early in the morning, when you had received a call that an accused person must be taken to Lieutenant Colonel Rapado, did you take him to any police station according to your evidence?
Re le na le khumana mogala wa gore molato fatswa o swanetse a ishiwe go Lieutenant Rapado lile la misha.
Ekuseni yomntwana 19 uma senithole uxolo ukuthi nihambise umsola ku Lieutenant Colonel Rapado namhambisa na.
Re mishitse Maroka police station.
Yes, we took him to Moroka police station.
Yebo samisa eMoroka police station.
Okay. Am I correct, Sergeant Mohane, to say from the appearances as they appear that he was booked in the early in the hours? It means the suspect on that day he did not sleep.
Gora gore bona ba bolela nnete na ge ba re ka moggo dilo di bonagalang ka gona jwalo ka ga ile gore yena o ile a ngwetswe gore o fitlhitswe mo gare ga masa ra gore molato fatswa a se a robala.
Ngeke lo bonala ngayo ke uthwakishwa ngasikhathi sini bona sengathi umsolo azange kuthole ithuba lokulala kunjani?
Ke a gana ka roba robetse koloing ya ranger tsa maleng.
I dispute that as he was sleeping in the vehicle as we were driving.
Hayi ngiyafika la ngoba ayilele emotweni ngesikhathi sihamba naye.
Okay. But he was not put into the police cells where he was allowed to sleep.
Efela ga se a tsentswe ka diseleng mo a ile madumelelwa gore a robale.
Ukuthi azange afake amaseleni la kufanele ulale khona.
As a court, please, my lord, what is the basis for counsel to say that the accused was not put in a cell and allowed to sleep?
My lord, I'm seeking clarity from the witness looking at the time when he was booked out, my lord, from the cells and the time when he was booked back in the early hours. That's why I'm just getting clarity from the witness. Maybe he was allowed to sleep. That's why I'm just getting clarity from the witness regarding that.
As I
Because he was
understand the
there.
evidence, these witnesses, they were from Pukeng, am I correct?
Le lebeletswa Phokeng
Ka di 18.
Or Chabani, whatever.
go ba Tlhabane.
Okay.
Lebeletswa kae?
That's our poll. Okay, fine.
I do not recall.
Okay,
my
yeah,
lord.
continue with your questions.
Thank you, my lord. You can't answer that. You can't recall, or you remain with your answer to say he slept in the vehicle when you were traveling.
Le santse le yeme mo karabong yela ya lena ya gore o robetse ge bentse le reile.
Hona le mo
Ukuthi walala emotweni ngesikhathi nina.
hona le mo re mosheditseng ka mogare a robala ga nyane mara ke tsona robetse nako e kae.
There is a point where we took him back to the cell and he slept a bit, even though I do not recall how long
Khona
did he
isikhathi la
sleep.
sambuyisela phakathi ukuthi alala wala isikhathi sinana sakhumbula ukuthi sasinana.
Oh, okay. I can refresh your memory because I have recorded the entries. From Pukeng, he was booked out 8:15 in the morning and he was only booked in at 2:30 on the 19th of June.
Ba re batla le go potsa go bana ba di-wet fast go tloga Phokeng.
And then he was charged. He was
Ka
charged at,
8:15 go fitlhelela ka 2:30 ya masa.
yes.
Sukela ephukeni wakhishwa ngo-8:15 waze wayobuyisela phakathi ngo-ekuseni ngo-2:30.
And then he was booked out at 4:50 after that entry.
Ba ntshiwa ka 4:50 ka moraga go ngwetswe jwang. It is correct.
Can you recall anything or you can't recall?
Go na le ntho e le kgonang go e gopola go baka le sa gopola.
Sakhumbula noma awusakhumbuli?
Go gopola gore re mtsentšhitše diseleng ya re boa.
I
Abara-
recall that we had placed him in the cells when we came back.
Ngiyakhumbula ukuthi sampensela emaseleni asesibuni.
Bile re mo ntšhitše ka diseleng gape re tsamaya.
And we took him out of the cells when we left again.
Yes. So
Sakhipha emaseleni ngemasisamba futhi.
if I understand what you are saying, so you would have booked him, you would have put him into the cells after 2:30.
Se se bolelang gore lena le mmušeditše diseleng ka mora ga seripa ka mora ga iri ya bobedi.
And he was
Nami ngidesela emaseleni emuva ka 2:30.
and he was taken out at 4:50.
La montšha ka metsotso ye lesome ka pele ga iri ya botlhano.
Sona semkhipha ngo-4:50 futhi.
That is correct.
Okay, kunjani?
So in other words, it means he was only detained for 2 hours. He was only put into the police cells for 2 hours.
Se se bolelang gore o tsentšhitswe ka diseleng iri tše pedi fela.
Ke nnete.
Ukuthi-ke buyisela emaseleni wahlala nje amahora amabili athi yena.
Okay. And he made the statement.
It's actually not 2 hours. We don't want to be pedantic, but it's more than 2 hours. 2.5 hours minimum to 2:25.
Manus, the witness can correct that. The witness is the one who knows better. If I'm not giving the correct estimate, you know how long was the suspect put into the cells.
Di ka lo magareng nako tseo. Tša 3 hours and 2.5 hours.
The time could be between 2 hours and 3 hours.
Isikhathi esiphakathi kwethu namahora amathathu.
Okay. From my calculations, from 2:35 to 4:40, it gives me 2 hours 20 minutes.
Go ya ka yena ge a se tša dira di-calculation go tlogelela ka 2:35 go ya go 4:50 e mo nea di-iri tše pedi le metsotso e masome a mabedi.
Well, okay, so let's discuss it first, got 2 hours 50. We go for 4:50. I'm a horror maybe. Some of our Mashumama Shana,
we wait till Hoban again.
You have said it correctly, so.
Oh, thank you. And it is your evidence that when he was taken to make the statement, sorry, my lord, not that can I rephrase? Not that it is your evidence. Am I correct to say that when accused number 2 was taken to Lieutenant Colonel Ropadu, he had not slept, he had only been kept in the police cells for 2 hours 20 minutes.
Ke nnete gore molatofatso ga be a ishiwa go lephodisa Raphato yana ga se a robale o lo jetso fela ka diseleng di re tše pedi le metsotswana.
ngabe kuneqiniso yini mangithi-ke umsola lesikhathi angena ngaso emaseleni nokuthi athathwe kayiswe esekhishwe siyiswa ku-Lieutenant Raphato wayiswa nje wayehlala nje imizuzu amahora amabili nemizuzu.
Nka se ra robala ka ge ba isha diseleng ba ishwa ke maphodisa mo police station eo.
I cannot say he did not sleep because when they are taken to the cells, they are taken by the police officers from that police station.
Angeke ngisho ukuthi engadlanga ngoba uyiswa emaseleni bahanjiswa amaphoyisa lapha esileso station.
Okay.
Sorry, I don't want to interfere, okay? You see the defense that was put by Mr. Mgomezulu is that this witness, accused number 2, was never taken to Raphato. He was taken somewhere to be assaulted, choked, etc., etc., etc. Inanda comes there, opens the boot of the car, gives him documents, sign here, sign there, sign there. Assaulted again, then they realize, oh, something has not been signed. Then they take him to Morocco now. And when they get there, are you with me?
Yes, my lord.
These versions, I want to be fair to you, Mr. Mgomezulu, and you, they are mutually destructive. Because the way you are putting it, it appears as if you are not disputing the evidence of this witness. When in fact, according to Mr. Mgomezulu, he never ever took Mr. Tinzi to Raphato. He met somewhere in the hospital, etc., etc. Keys were given, blah, blah, blah. Taken to an open space, assaulted. I'm just saying it.
Thank you, my lord. I was just referring the witness as to how the incident unfolded during the time when he was booked out up to the time when he was booked back in the early hours.
Okay, no problem.
Yes. I have not touched the issue of the accused and the Lieutenant Colonel Raphato. I'm just talking about the night preceding to that incident, my lord. And I did not get the answer.
It's a Karawayal Nabirin.
Kana le rileng hapa ka re sa ba disturb ka o sheletsa ka
What
ka
was your
kopela.
question as you have distracted me? May you please repeat the question?
No, I had said it means for the whole night the accused had not slept. If he had slept, he only slept for 2 hours that he was put in the cells.
Bona ba rile go ra gore bošego ka moka molatofatšwa ga se a robale ge e le gore o robetše yena go ra gore o robetše di-iri tše pedi fela.
Angisho ukuthi umsola akazange alale kulobo busuku. Uma u-2 hours ukulala amahora amabili kuphela.
Ra robetša ra go robetša nako eo ka ya 2 hours and 40 minutes, 20 minutes.
He slept, meaning he slept that 2 hours and 20 minutes that you have referred to.
Okay.
Wayalala wona yona nama-hours ukhuluma ngawo amabili.
And then on the 22nd of June 2020, when the accused was taken to court, he was taken not for Nongoma case. Am I correct?
ra gore ka di 22 tša June molatofatšwa ga se a ishiwa kgotlatshekelo yena o ba sa išetšwe molatola wa nongo
which he was
Mhla
detained.
22 kuJune umsolwa umeseyiswa enkantolo wengayiselwa leli cala kaNongo.
o be a tswaleletswe wona
Lelo ayeboshelwe lona.
No, we should for Puking.
he was taken for cocaine
For purposes.
Ayiselwa icala lasePhukeni.
Okay. And from the evidence of Jonathan, Mr. Buthelezi, and Mr. Buthelezi, they testified that they were asked by yourself on respective dates when accused number 1 was taken to make a statement to Lieutenant Rapadu, and when accused number 1 was taken to make a statement to the magistrate, Ms. Cronje. Their evidence is that they were requested by yourself to escort you as you were traveling.
Jonathan le Buthelezi
I'm sorry, accused 2, my lord, not accused number 1.
Jonathan le Buthelezi bona ba boletse botlhatsi ba gore ba be ba boditswe ke lena gore ba sepele le lena ge be a ilo dira statement sela go magistrata e leng gore molatofatšwa wa bobedi e leng Mtanzi o be a ilo dira confession yewe goba statement seo
Usho ukuthi ubufakazi obuvela kuJonathan novela kuThelezi ukuthi umsolwa wayeswa kulaphathi isa statement futhi wayeswa futhi magistrate ukuthi ayobhalisa statement nokuthi ke nina wena wabacela ukuthi bazoniphelezela
E re ke tlhalosetse gore ka tsela e.
may I explain it to the court in this way
angichaze ngale ndlela kamngakho
Ekurhuleni Metro Police Department I khopetšwe ke Brigadier Gininda le di supervisor tša Ekurhuleni Metro Police Department go thuša ge re go sepediša di suspect tša rena ka ona molato.
The Ekurhuleni Metro Police Department was requested by Colonel Gininda and the supervisors to accompany us as we were traveling with the suspects in this matter.
abasendleleni ke bathelwa uGininda wakhuluma nezikhulu zasekhululeni ukuthi kuzophelezelwa ke lamasonto.
Okay, in other words, you are saying you were never involved in the request that was made requesting the members to give escort to yourselves.
Ka mantswe a mangwe lena le re ga senke le be karolo ya kgopelo yewe ya gore le kgopele gore batho ba uwe ba tlo sepela le lena.
Usho ukuthi wena ke ungenasandla lesicelo lesi sokucela ukuthi niphelezele.
Ka ge šetše ba ba file tumelo la go šomišana le rena.
As they had already given them the right to work with us,
Njengoba sebegunyaziwe ke ukuthi bazosebenzisana nathi.
Bale ba re fa tumelo la gore rena re re ka mo fase mo re kana ra founelana ge go na le mšomo tshwantse re o dire.
and they gave us the right to contact each other if there was any duties that we were supposed to do as we were working on the ground.
Thina ke la abaphansi ke sasisisi ukuthi thindana uma kukhona umsebenzi wadinga ukuthi sisebenzisane kuwo.
Okay, so as you had been given a right to communicate, were you given specific members to request from the metro each and every time when you needed their services?
Ba ile ba lefa batho tsoko gore lena ga ile gore le tlhoka tšhomišano le bolele le batho ba rile.
Ade ukuthi nanitsheliwe naniwe ithole ukuthi ningasho ukuthi obani enifisezisana nabo basenkundleni ukuthi khona umsebenzi ofanele wenziwe.
Ke nnete ba re file yona group eo.
Correct, we were given that particular group.
Beqiniso sanikwa bona ke nabo bantu.
Okay. In respect of accused number 1, in Albertine on the 30th of May, were you also present?
Le be
In
le le
Albertine,
ngwana
Mr. Fingers?
ka Albertine ka kwa ka di 30 tša May go ya le molatofatšwa wa mathomo.
mayelana nomsolo wokuqala ngokuhlala 30 kuMeyi nani seliwe yini ukuthi nihambe nalo msolo ni Alberton
On the 4th of June. On the 4th of June.
Barakadi 4 cha June.
Actually
the 5th of June.
Yes, it is correct.
Who arrived first at the Alberton station between yourself and Jonathan and his crew?
Go fitlhe mang pele magareng ga lena le Jonathan le setlhopha sa gagwe. Ba sepodising sa Alberton.
a ke sa gopola botse re fitlhela mampela a ke sa gopola botse mara bona ba fitlhile le rena re fitlhile
I do not recall who arrived first. However, they arrived and we also arrived.
Okay. Do you recall as to where were they waiting, Jonathan and his team?
Le sa gopola gore Jonathan le setlhopha sa gagwe ba eme kae?
ya gopola
Yes, I do recall.
Where?
Ba eme kae?
Jonathan ne Timberlake ba bemedi
ka ntle ka police station
Outside the police
ba
station.
beme ngaphandle ko police station.
Thank you, my Lord Medical. Just bear with me. Thank you, my Lord. I've got no further questions.
Okay. Yes, Mr. Oh, you said you were waiting. Mr. Baloyi, any re-examination?
You were asked by counsel for accused number 1 and 2 regarding the appearances of the accused in Boksburg.
Ke botsitswe ke ramolao wa molatofatso wa mathomo lo wa bobedi ka go tswelela fua Boksburg.
This is now as far as Exhibit E is concerned.
Ba re go ya ka botlhatsi bola ba E di se exhibit E.
Yes,
of
Exhibit EE
EE.
on the 27th of October
Ka di 27 ja October
27 October
2020
ngwageng wa 2020.
as to whether you had permission from the station commissioner to postpone to postpone accused number 2 to Valeria police cells.
Gore lena le be le filwe tokelo ke station commander gore le ka molatofatswa wa bobedi yena le ka moisha diseleng tša Deleria.
okuzobe ukuthi ke nanayo imvume yokuthi amasola emaseleni asevaleka ngokuya kwimvume nayithola ngokuya ka-station command.
That is correct.
Yebo kunjalo.
Yesterday we handed the original of exhibit EE
Maobane re fane ka tokomane yela ya EE.
Zolo-ke khona-ke i-exhibition esikhuluma iyona.
Bakgopela lwane.
just want to draw your attention to a letter my lord, the letter would appear right almost in the middle of the proceedings. If we can just place the contents of the letter on record.
Ba re ba nyaka gore le ye go lengwalo le lebale le godimo le kgone go kwagala.
Yena uthi ngifundele encwadi ngifundele enkantolo.
Language gore the station commander South African Police Service Valeria.
Baruti station commander station sase Valeria.
Mo godimo no inquiries Colonel Toka.
Balela ka ngenza nyaka uthi inquiries.
On top it's written inquiries, Colonel Toka.
Home why address it the Magistrate Senior Public Prosecutor Boxback Magistrate Court Boxback.
And it was addressed to the Magistrate Senior Public Prosecutor in Boxback Magistrate Court.
Permission to place a suspect at Valeria police cells.
And it reads as follows. Permission to place suspect at Valeria police cells.
Here, point number 1 is here with permission to place under mentioned suspect at Valeria SAP cells for further detention.
Point number 1 is read as follows. Here with permission to place under mentioned suspect at Valeria SAPS cells for further detention.
Omega Mama Shakaning in which case number 4/636 of 10/2014.
And in the box is written case number 4/636 stroke 10 of 2014.
Umel Shakana la latela language gore name of a suspect Bongani Ntanzi.
Second block it's written name of the suspect Bongani Ntanzi.
Shakana la mafelelo in which Colonel B. N. Gininda.
The last block is written Colonel Investigating Officer Colonel B. N. Gininda.
Point in which permission is granted by Colonel Toka SAPS Valeria.
Second point, it's written permission is granted by Colonel Toka SAPS Valeria.
Mofase assign Enguche Station Commander Colonel SAPS Valeria MS Toka.
And underneath his sign, it is also written Colonel Station Commander SAPS Valeria MS Toka.
Station Commander MS Toka.
Kamofase Amala date 2020 of 10/27.
Underneath it's written a date 2020 of 10/27.
Which is also fine. No, so 27 October 2010.
A copy certify again na PV Mohani, custom pisat leg of the court of Boxback Police Station.
And a copy.
Court, Boxback Court.
A copy was certified by myself, Mr. Mkhani, with the stamp of the clerk of the court. That is all.
You were also asked by counsel for accused number 1 and 2 as to how you know Mr. Njiaku.
Ilela botšišwa gape gore Mr. Mjiako yena le motsebi le jwang ke jwa ka ke mmele wa molato fatswa wa mathumo lwa bobedi.
Ummeleli kaMsolokane wesibili babuzayo futhi ukuthi mazi kanjani uMujiyako.
And you then gave an explanation. Can I once again ask you to turn to the transcribed version of Exhibit EE on the 27th of October?
Ba le go mola yele gore e typilwe ya di 27 October yona ye ya EE.
Manje siyabona
La fana ka tlhaloso.
exhibit ile akhombisa khona ukuthi kwakuqoqe phansi.
Ngiyayibona.
Yes, I can see
Who
it.
appeared for accused number 2?
Ke mang o be ile mmele wa molato fatswa wa bobedi?
Ubani owayemele umsolo wesibili?
Ngingwatsho gore Mr. Ntokozo Mijiyako Attorneys.
It is written Mr. Ntokozo Mijiyako Attorneys.
So lapha-ke uNtokozo Mujiyako owasefemini labameli lakaMujiyako.
The case was then postponed to the 27th of November, the correct 2020.
Molato o o ile wa hlekisetswa morago o issuwa go di 27 tša November 2020 go jwale.
Leli cala-ke laselisele ngomhlaka 27 uNovember 2020 akunjalo.
On the second page.
Mo paging ya latela.
Uthasini elilandelayo
Ke nnete.
It is correct, I confirm.
kuyiqiniso.
Who appeared for accused number 2?
Ke mang o be a emetse molato fatswa wa bobedi?
Ubani-ke owayemele umsolo wesibili?
Isangwetswe Mr. Mijiyako gape.
It is still written Mr. Mijiyako.
Kusabhale yena obaMujiyako.
Thank you.
Arba leboga.
Are you through with that letter, Mr.?
There's a formal letter that is on record. If I can just ask you to put that, the contents thereof on record.
Ba re go na le lengwalo shile ba kgopela gore le lebale le tle le kgona go bala.
Khona-ke incwadi-ke engifisa ukuthi uyifunde ukuze iqoshwe phansi.
Mo mengwalong e megolo godimo ga letlakala e ngwetswe Mijiyako Attorneys Incorporation.
In bold on top it is written Mjiyako Attorneys Incorporation.
Ngamagama-ke amakhulu ubhale lapha phezulu ukuthi abameli bakwaMujiyako.
Walatala mengwalo ring the Director of Public Prosecutions, attention Advocate Jibaloi, per email on Ngasibali.
Then it is written the Director of Public Prosecutions, attention Advocate G. Baloyi, and an email address. And the witness says he would not state the email address.
The
Kuyaye
date.
kubhalwe-ke
Date yona.
kuqondiswe kubashushisi lapho kubhalwe khona ukuthi kuqondiswe ku-ushushisi ku-Advocate G. Baloyi.
Dating was 3 March 2021.
It is dated the 3rd of March 2021.
Ukuthi kubhalwe usuku lomhla 3 kuMashi 2020.
Yona ebala lai dear says.
It is written as follows. Dear says,
Kubhalwe nje ethiwa abanumzana.
Ngala gape ka mengwalo e mekutunyana RE/Ntanzi for Soloras case 636 of 10/2014.
also written in bold, RES stroke Danzi Phosphorus case 636 10 of 2014.
Kubhalwe-ke lapho ukuthi sihloko sithi Ntanzi icala lasephosphorus 636 of 10 of 2014.
Point number 1, we confirm that we act on behalf of Mr. Vongani Sandison Ntanzi, who is accused number 2 in the above matter.
When number 1 is read as follows, as the witness has just read it, my lord.
Kubhalwe kanje ukuthi thina simela uSandiso Ntanzi kuleli cala.
And then, immediately after the last court appearance, Mr. Ntanzi withdrew a mandate as his attorneys of record and opted to be represented by the Legal Aid Board.
That is the second point, my lord.
iphuzu lesibili ke lithi ke hayi uSandiso Ntanzi ke wase uyasikhipha njengabameli abamele waseqoka ukuthi uzonimelwa abakwa-legal aid board.
Yabarari yona ere, we also not been receiving financial instructions from Mr. Ntanzi.
Okwesithathu ke kuyashiwo lapho ukuthi cha asizange sikhokhelwe.
Point number 4, Mr. D.N. Mujiyako, who has previously appeared on behalf of Mr. Ntanzi, is no longer with our firm and has joined the Cape Bar as a people advocate.
Manje futhi wabhala ngephuzu lesine ukuthi uBM Jakho owayemele umsola ngalela usashiya kuleyo firm leyo wayesebenzela eCape.
Yabuhlani yona ere, I am mindful of our duty to formally inform the court about these developments and to withdraw as Mr. Ntanzi's attorneys of record.
Manje wasecela ukuthi hayi ufisa ukuthi inkantolo yazi ngalokho ukuthi ke sebeshiye phansi ukuba abameli kuBaba Ntaka.
However, due to a family bereavement, I am unable to make it to court on Friday, 5 March 2021, and my colleagues are out of the province.
Ushuthi ke ngeshwa ke ikhona ukusuzelele ekhaya ngikwazi ukuthi ngomhla 5 kuMarch ngiyovela enkantolo ukuthi ngiyosichaze ngoba kodwa ke futhi ke okunye ukuthi abekho abanye ngisebenzisana nabo.
Point number 6, may I therefore humbly request your assistance in informing the court on our behalf about this development and to request that our non-appearance be excused and our withdrawal of attorneys of record be confirmed.
Manje ngicela kwazisa inkantolo ngalokho futhi uphethele uphinde inkantolo ukuthi sesishiya phansi njengabemeli balomsola.
Point number 7, thank you in advance for your kind assistance herein.
Kike hayi sizobonga usizo lwenu mayelana nalokho.
Yours sincerely, Mijaka Attorneys Incorporation, DL Chia.
Kike uphethe lana uDL Chia wabamjiya attorneys.
Thank you. It was put.
No. Put in the practice number. Remember the allegations.
Yes.
Subtle allegations that this gentleman is a fly-by-night counsel or attorney.
Yes, just put the practice
So
number.
put the
practice number.
legal practice number.
Mofasi Inwichi, legal practice council number.
At the bottom it is written legal practice number
18209.
Manje la kufanele inombolo yabo yokugunyaza ukusebenza njengabameli ithi 18209.
CIPC reg number
Balothi CIPC reg number
2017 stroke
2017 stroke
149 229 stroke 21.
stroke 21.
Mgomegamo Inwichi vet number
and it is also written the VAT number
Ukade VAT number
451028
451028
4914.
4914.
Barbara Leboga.
Mr. Baloi, put the address of this attorney on record because I see it here.
Barbara Lekabala le address.
Because we don't know whether he has an office or not. When the evidence was unfolding, it doesn't exist apparently.
Okay. Put.
Address ya gagwe ba la ke tsela e
Ikesi la ikele la ke lifundeka kanje.
The address is read as follows.
10 8th Street, Melville, Johannesburg.
10 8th Street, Melville, Johannesburg.
Wale phone number.
Should I read the phone number
code?
as well, my lord?
Yeah, the code.
Telephone
Postal
jala
code.
Our code is 2109.
2109.
Telephone number
Cingo
plus 2711
plus 2711
482
482
2325.
2325.
Email address
Email
info@mjiago.com.
info@mjiago.com.
Website
That's your website.
www.mjiago.com.
www.mjiago.com.
Directors, is it necessary?
Yes, it's not necessary, but
Hey, it's necessary. What do you mean it's necessary?
no, we're just going to refer to the senior
Because
associate
this gentleman practices in partnerships.
as a good.
It's not a sole practitioner.
As a good, we just wanted to put the senior associate on record. Who's the senior associate?
Imam Womogolo.
Obani ababambisene nabo abaphezulu.
The senior consulting attorney.
Are you referring to the one that is written
No,
senior?
senior associate.
Directors.
Well, we just mentioned the directors.
They-
The directors.
Oh, okay. Just
You
put
don't
the
have to mention the qualifications. That the directors are so and so and so and so and so and so.
Barley Bale, the
The
director.
senior associates. So and
Abakhombisa
so.
abakhona la.
Director Iridineo Chia, Managing Director,
Batumi bafundisa idinyojiya,
LLB Limpopo.
LLB Limpopo.
Katiso Mphahlele, LLB Vets.
Batukathiso Mphahlele wase LLB oyithole vets.
LLM Labor Law UP.
Atwathola ne-LLM yomthetho wezinsibisebenzi oyithole UP.
Certificate in Law Dispute Resolution Stellenbosch.
Atwathola isertifiketi sokuxazulula sase-Stellenbosch.
Senior Associate in Togozo Mjiago,
Senior Associate uDozo Mjiago,
LLB Vets,
thole LLB vets.
PDM Vets.
Atwathola EDM nase-vets.
Natalaki Senior Consulting Attorney Melanie Naidu,
Athiyokhona i-senior consulting attorney kumelani nayidu.
BA Vets,
Athola i-BA yase-vets.
LLB Vets,
LLB yase-vets.
LLM Vets,
Athola ne-LLM yase-vets.
Advancing Diploma in Banking from Bankers Institute of South Africa,
Athola isitifiketi sase-banking council yase-South Africa.
Junior Consulting Attorney Faith Huntley,
Athi-ke ummeli uBethi Huntley,
LLB UNISA.
thole LLB yase-UNISA.
Iwala ka tsela eo.
Thank you. It was put to you by counsel for case number 2 regarding exhibit RR. That is now the court proceedings in Phokeng.
Moleledi wa molatofatso wa bobedi yena o ile a bolela ka botlhatsi ba RR e leng dilo tse di diragetseng kgorong ya Phokeng.
And msona wakhomanje ukwenzeka lapha lasePhokeng lapha kwe-RR.
Inete.
That is correct.
Kunjani?
It was put to you that accused number 2 did not appear in court on the 22nd of June 2020.
Ba ile ba le botsa gore molatofatso wa bobedi yena ga se a tswelle kgorong ka di 22 tša June 2020.
From Msibazana, vele kato kati 2020.
Yagopola.
I do recall that.
Yakhumbula lapho.
If I can ask you to turn to exhibit RR.
Ba re le go botlhatsi ba RR.
Vele yosheka lapha ku-exhibit RR.
Shiki Tswere.
Yes, I am in possession of it.
If we turn to the 4th page from the beginning.
Ba re le tsebeng ya bone.
Angaya ekhasini lesine.
Yes, can you just place on record what's written there?
Ba re le re botse gore le pageng la bone go ngotsweng.
Masharuti ekhasini lesine kubhalwe lapho.
Mawodimo ngwetjo P04.
On top it is written P04.
Kusuke kubhalwe ukuthi P04.
A171/20
A171/20
on 13 of 7 2020.
on
On 13/7/2020.
on 13.
No,
Yes.
the 4th page from the beginning.
Ba re le renyana page la bone go tlogelleng mathomo
Eqaleni.
leki ke la mathomo la bobedi la boraro la bone shediwele le baneng.
Yes, Can you just put that on record?
ba re le re balle yona e uwe
With your agenda 29/6/2020,
Jwale kwa hloka na go can you give me the date again?
29
29 of 6, 2020.
29/6/2020.
Legal aid in custody, no bail.
Bathi ke wa emele legal aid ungaphakathi akanayo ibhili.
And what is your recollection? Was, as far as the presence of the accused at court on the 22nd of June 2020 is concerned?
lena kgopolo ya lena e reng ka go tswelela ga molatofatšwa ka di 29 tša June 2020
Manje wena khumbulani ba ngifika ngisole enkantolo mhla 29 June 2020.
Molatofatšwa o tšweletše pele ga kgoro ka yona di 29 June o išitše ke nna ka sebele.
the accused appeared in front of court on the 29th of June and I personally took him to court
No, we're talking about the 22nd of June.
22nd, yeah, 22nd, oh yes.
on the 22nd.
Sorry. Wavele enkantolo mhla 27 June 2020. What happened is
Right, then on the 29th of June, just the following page, 29 June 2020,
Ka di 29 June 2020
manje mhla 29 June 2020.
just plays on record what's written there.
re botše
By the
gore
magistrate?
ba reng.
Manje sifundele lapho ukuthi kuthiwani.
Yes, 29 June 2020.
Agenda 29 June 2020, legal aid in custody, no bail.
Jwale kwa hlukana mhla 29 June 2020 umsola ubuyisela ngaphakathi kumele i-legal aid futhi akanayo ibhili.
Yes, and the following appearances on 29 June.
ye latelang the 29 June
Here the page 4, the 13th of 7, 2020.
No, 29
of June. Where is it?
It's written page 3 at the top.
ba re godimo e ngwetše
Page
page 3
3. Actually, page 3.
there is no page 3 on this document this one does not have page 3
Yes, was the entry there?
Which is page 3, A171/20.
By page 3 number
A171
A171
from 20
stroke 20.
In which on the 29th of 6, presiding officer Miss A. Rose.
Jwale umeli
Miss A. Rose.
ngalelo langa kwaku
A
Rose.
A was.
Prosecutor Mr. Stroke Mr. Mohapais.
Futhi kwaku ecele
No, 29 June is written page 3 after.
Yeah.
Yes.
Yes, I'm reading.
he was the witness on 29
Oh, there, okay.
Get on record.
ba re le ba balle ye
Or Yamatomo in which your court not working.
first one is written court not working
jwale uqala-ke inkantolo engasebenzi.
Acute not brought in court isolation for COVID-19.
Jwale umsolwa kalethwanga enkantolo ngenxa yokuthi kufanele ahlukaniselwe-ke udaba lwe-COVID.
Agenda to the 13th of July 2020 in absentia in custody, no bail.
Jwale kwicala lahliselwe mhla 13 July 2020 uyisela ngaphakathi uzobe engaphakathi esituksini kodwa-ke icala lihlesiswe engekho.
Do you remember this appearance of the 29th of June 2020?
isa gopola taba ye ya di 29 tša June 2020
Khumbuka
gore
wenza
a se
mhla
atwelele
29 June 2020.
Egaropola.
yes I do remember it my lord
Yebo ngiyakhumbula.
Do you remember as why the accused was not before court on the 29th of June?
le a gopola gore gobane
2020.
molatofatšwa o ba sego kgorong ka di 29 tša June 2020
Uyazi ukuthi yini indaba umsola engekho enkantolo mhla 29 June 2020?
Ke ya gopola ga re go bona le a case ya COVID-19 Valeria police station.
Yes, I recall because there was a case of COVID-19 at Valeria police station.
Yebo ngiyakhumbula ngoba kuthiwa ngayela wathola ukuthi kukhona owayephethe isifo sobhubhane se-COVID eValeria. I don't know.
Thank you. Counsel for accused number 1 and 2 also referred to exhibit VV1.
VV1.
It's a report from Tlhabane.
So American sort of kind of video.
Dental services.
VV1.
Okay, one she.
Yes, I can see it. It is in front of me.
The date is the 22nd of June 2020.
Date is 22 June 2020. That is correct.
You mentioned in cross-examination by counsel for accused number 1 and 2 that you took accused number 2 for this dental examination after the court appearance on the 22nd of June 2020.
Lile la bolela re be le botšwe ke molao wa molaofatšo wa bobedi gore le nna le la mesha ba ile mo tlhola meno. It is correct.
What was the purpose of this examination, the dental examination?
Lebaka la gore a ile tlholwa ka menong e be le eng?
Kwakuyini isizathu sokuthi ayohlolwa amazinyo?
Really re phenya molato wa 636 wa kry le gore mo senepe se ba montšhintše go sona o ba na le gold go tswile motho ba rona le gold so be re tšhakwana sala ba le gold na mo menong.
Whilst we were still investigating the matter of 636, there was a picture which depicted a person that had a gold tooth, my lord, and we went to see if he has ever had a gold tooth before.
Manje kuzophenya lethu kwatholakala ukuthi khona isithombe la kuvela khona ukuthi wayenezinyo elinegolide. Manje sasifuna ukuthi simise lapha ukuthi kuyohlola ukuthi wake waba nalo yini izinyo legolide.
Can you just place these details under other details on record?
Ngele bale mola mo ngotse other details le di bale.
The other details with you. Look how too short the more.
Can you please show me where my lord?
Patient report.
Or patient report.
Operation, okay. Further details.
Further.
Yes.
Patient report have been admitted for a heart condition in 2014.
Ngomsolale wake wathathelwa wahlolwa ngokuthi kwaba nesifo senhliziyo ngo-2014.
Following mining accident.
Emva kokuthi ke kube nengozi yasemayini.
If I can ask you to turn to exhibit JJ.
I do not have JJ anywhere.
There's a copy. There on the S3, can you just put in record what Ms. Cronier wrote there?
Le ba botsa gore Miss Cronier o be a ngwetseng.
Tsela o tšene nkata Miss Cronier lapho ayibhale.
Ke bala ka mo ka
There where
page.
there's a star.
Oh,
bathi la kunenkanyezi khona.
I do not want to report any medical conditions or injuries.
Yes.
Athi akufisi ukuthi ngibike ngikulimala nokuthi lethe umbiko ngizempilo.
Except had a heart problem.
Manje ke ukuthi kwaba nesifo senhliziyo.
Thank you.
Sorry, that annotation by Ms. Konji, what date was it made, by the way?
It was on the 24th of June 2020.
24th of June. Okay.
Exhibit JJ.
2020. Exhibit J.
JJ.
JJ, yeah. That was the pro forma.
The performer.
Okay.
Now, if I can ask you to turn to page 2 of Exhibit VV1, the dental report.
Maria on page 2 with hatsi VV1 yela report ya botlholo wa meno.
Passing this exhibit BB1 ephuma ngamazinyo.
There's a clinical examination.
Bona le mo ile gore ba mo tlhola bona.
Khona ke la ba tlhola khona.
It was put to you by counsel for accused number 1 and 2 that accused number 2 was tortured, assaulted, and chewed on the 19th of June 2020.
Ba ile ba le botsa gore molatofatwa yena o ile tshwariwa a betwa gape a ka di 19 tša June.
Umsolo ummeli kaMsolo sibili uthi uMsolo sibili wothi wahlukunyezwa washaywa wasefakwa neshubhu ngomhla ka-19 June 2020.
During the oral examination, what was the finding regarding the general appraisal?
Ge ne a tlholwa ka menong bona ba boletse goreng
General
Mehlola ke kwabikwa kwathini
general appraisal normal.
ke konke kulungile.
Yes.
TM joints normal.
Ama-TM joints akahle.
Lymph nodes normal.
Athi ama-lymph node alungile.
Intraoral exam normal.
Bheka la ngaphakathi kulungile konke kulungile.
Lips and buccal mucosa normal.
Wathi ke isikhumba phakathi komlomo neindlebe zomlomo zikahle.
Oropharynx and tonsils normal.
Wathi ke ama-tonsil nala qoqoqo konke kulungile.
Palate normal.
Ke ngaphakathi emlonyeni ngaphezulu phahla lomlomo lona lungile.
Floor of mouth normal.
Thike lana ngaphansi emlonyeni konke kukahle.
Tongue abangwala silo.
on tongue they did not
Abakhulu
take anything.
mangalithoke ngoli
Elatela ngiri gingival and periodontium yangwala abnormal marwangwala ginginal recession actually wawali number 41423.
And it is written ginginal recession of 41 stroke 42 stroke 3.
Yes.
Thike gingival ne periodontium konke gingival recession of 4142 interdental spacing nakhona 112 to 122
Megamorphosis yangwala angle classification class 1. And then your teeth chart, interdental spaces, your 11 .12,21 ka mo tlase ya 23,12 ka re category la sa ona general
And on the chart, it is written class 1, interdental space 11, arrow 12,21, 22, arrow 23,12, and it seems like there are letters that were cut, my lord, as the witness cannot see them properly.
Njengoba lapho ukhombisa-ke ukuhlala kwamazinyo, ukhumbula-ke isikhala-ke siphakathi namazinyo, kuthiwa kunesikhala phakathi kwezinyo 11 lokufika kwelesibili nesikhala esingemva ka-21 bese kuba nesikhala phakathi kwezinyo lemashumi amabili nezinyo lemashumi amathathu kwase kubekwa-ke nesikhala ngaphansi kwezinyo leshumi nambili kodwa khona okunye okungaseceleni okugcineni kungasabonakali kahle.
The God, please, my Lord, this is 4:04. It's way past our normal time of
We're still
adjourning.
going to go on.
Can we adjourn about 1 or 2 further questions? Maybe then adjourn until tomorrow.
Okay, any objections? For adjourning at 4:04?
There is none.
My Lord, may I make a request on the? I'm not intending
You're
to.
not?
I'm not intending to interject on the evidence that the state is busy with. I believe the document that the state is busy with was not admitted under Section 220.
Which document is that?
The one for medical examination of the accused.
The one which? The one of the dental examination?
That's correct, my lord.
You told me that you agreed.
No,
You,
I just consulted.
Mr. Valoi, didn't you tell me that?
It was sent up by the defense, my Lord, and we said we don't object.
On one specific reason.
So you are objecting to its handing in?
My lord, it related to the date of the 22nd of June.
Yes, but the point
not
is,
on the
are you
contents.
objecting to the admission of that?
That's correct. That's correct, my lord.
You are objecting to it,
That's correct.
but it's before court now. You can address me tomorrow.
That's correct, my lord. I'll do so.
And who handed in this document?
It's the defense, my Lord.
Yeah, as I recall, Mr. Murubezulu himself. Okay. Can you number that order, that court order? Give it a citation. I don't know exhibit what. Are you with me?
Yes, it will be Exhibit W.
Exhibit
WW.
Exhibit WW. That is the apparent confidential report of the sergeant. Are you available tomorrow, sir?
Yeah.
Okay.
My Lord.
10 o'clock tomorrow.